Who? On the fair on the fair, that as part of the petitioner, this is the matter of the matter six. New matter? No, no. Then you go to the registry. Go to the registry. Huh? Matter 4 years. Right. On the prayer for a judgment made by Mr. R.R. Gold, then a copy for the forest department, comma, who submit that has taken the consent of the petitioner. This is the matter after the pending matter. New.
Mentioning this matter for withdrawal, that the matter may come tomorrow.
Okay. What happened to the other one? Yesterday. Okay, tomorrow. Yeah, please. Okay, petition method of this over higher. I can wait for. What is the number? What is the number? I have filing number 781010. It's a new IA. New IA or a new? When? Tomorrow. Maybe it's not for tomorrow.
Notify the commissioner for the.
Registry, madam. Registry, go to the registry. Review.
Monday,
Registry file.
because of the my mistake, the documents were not clear. That was to get the cancer metal, date of birth, there was some dispute. At the time of finding them, and I have collected all. Monday,
Order dated. The review, here's the review of which order? Order is of which date?
because I pilot on
No, the writ petition was disposed of which date?
February,
Huh?
February. Monday.
Monday, wait a minute. Anyway, I think it's okay. Yeah, sir. But I take to mention for withdrawal for tomorrow, my. Hello.
In respect of item number 11 and 12 of supplementary discussion.
Yes.
And maybe engage some, engaging with, considering maybe engagement. So,
Who is newly engaged?
MC Borago. You will file vocal comma.
On behalf of,
And MC Borago, or on behalf of.
on behalf of the petitioner or behalf of the, huh? Item 11 and 12.
11. It is some after 2.
No, there is more difficult.
11.
10 and 11.
Then 11 supplementary.
Yes, it's 10 and 11 are tagged together, not 11 and 12. 12 is a different case.
So, fine.
Mr. Bora is not there in item 10, sorry. He is not there in item 11 also.
Also, we are going to file vocal.
Who is going to fight Wakam Tamba?
Bora. So, Bora will file.
You see, you want for item number 10 to 10, I'm sorry, 10 is not your case. Petitioner is Mr. Indrajit Chaudhary. You talk. It seems that they don't want you, Mr. Indrajit.
So, they have a
They don't want you. They've hired a new bunch of lawyers.
I need to be clear on this. If your lordship has a look at the Cosler,
Ah,
originally, by the senior counsel, Mr. A.C. Barbara was engaged,
that is for item 11.
11. So now perhaps they might have engaged someone else, I don't know, because I don't have any instruction.
You are appearing in item 10.
both the items.
Both 10 and 11.
That's what. That's why we listed it because
Yes.
now
No, the check for. In that case, my lord, I would not like to.
The state should be vacated, lawsuit. This way. they
Ah,
make
correct,
lawsuits.
correct.
Let the state be vacated.
we will get the state.
Then let it be heard, whatever.
You see, no point.
Your lordship, will-
The,
your lordship will just allow 10 minutes time.
Ah, you
let
have
my-
instructions.
Let my junior take instruction. If they have engaged someone.
We'll
I
list
do
it
that.
at 11 o'clock. We'll
Mal-
call for it at 11. You find, you
Mal-
find.
Yeah.
Who are you engaged counsel? Then why, then you go, you relax. Mr. Counsel, first of all, you are not an engaged counsel. You are speaking for some other counsel who we have got no idea, no clue. Sorry, tell your counsel who spoke to you to either come to this court and say what is there, because you see now that senior counsel was there
Without an NOC, I am.
and no objection given from them. And yesterday we heard this matter. Was yesterday, day before? 2 days back, we heard this matter.
The third change of council. If it is so.
Whatever. This is not the way to do it.
Our concern is to stay what.
No, your concern is stay order. My concern is to dispose of the matter.
Correct.
Because it was listed, it came out in a supplementary list. And then I have to go through it. It's quite thick also. 11 o'clock. Tell the client, tell the counsel to come.
Date please, Your Lord. Yeah, well, Lordship, turn to page 142 for a while.
140.
140. Yeah, my lord, the respondent number 2, my lord, has quoted an IT 142, Your Lordship will find, my lord. Well, it's regarding supply of dietary articles under Zone 5 jail for Assam.
Hey, 140 is
140, 140,
142.
140.
Oh, okay, yes.
Lordship will see, my lord, the name of the word,
Yes.
supply of dietary articles under Zone 5 of jail for
Correct, correct,
Assam.
correct.
Now your lordship will turn to page 169, my lord.
Yes.
169, your lordship will find, my lord, the Zone 5 jails, my lord. Sorry, my lord, Zone 5 jails, my lord. There is central jail at the top, my lord. My lord, there are 5 jails, my lord. Central jail, Tesco, district jail, Vishwanath Pandi, Udalguri, Bangalore, Borpeta, Pakistan, Nalbari. And these are the articles, my lord. My lord, the petitioners, my lord, earlier used to supply the dietary items
During which year?
from 2016 on.
Till last year, till now.
Till now. Now your lordship will kindly turn to page 108, my lord.
108.
108, my lord. It is, my lord, the tender of the previous year, my lord. This is the tender of the previous year.
Yes.
Now lordship will turn to page 140, my lord, for a once. 140, when lordship will see, my lord, there are several groups, my lord. Group A, Group B, Group C, and Group D. So earlier, my lord, earlier tenders, my lord, there were 4 or 5 groups, my lord. Now they have this group, my lord. Together. Now your lordship will, when I am agreed by the, my lord, page 164. Page 164, clause 4, my lord. Here your lordship will find the tenderer to have to submit the minimum average inward turnover for the last 3 years. The minimum average inward turnover of the tender for the last year is 11.4. I am agreed by this, my lord. Now your lordship will kindly turn to, my lord, page 151, my lord, of this tender, my lord.
Yes.
Here, your lordship will find below, my lord, 4.1.2, my lord, purchase and price preference. My lord, Roman 1 matter. In exercise of power conferred in section 11 of the micro, small and medium enterprise development council, the government of Assam has notified the procurement preference policy of Assam 2065, 2021. In respect of procurement of goods and services produced and provided by the micro and small enterprise partner, state public sector undertaking and its aided. Now, if your lordship
Is there any 2015 act?
yes, I am providing balance that further. First paper lordship, that further thing is the Ministry of Law, Section 11.
Let me see which act is this.
Section 11. For facilitating promotion and development of micro and small enterprise, the central government or the state government may by order 85 from time to time different policies in respect of procurement of goods and services produced and provided by the micro and small enterprise by or department as the case within audit needed to. With this, my lord, the government of Assam has issued a notification. Under section 11, my lord, the government of Assam, my lord, had prepared this for Assam procurement preference policy.
You see, this talks of a procurement policy
Yes.
of 2015.
Yes, that's why I'm coming, my lord. So, lordship is the definition.
Is there a procurement policy of 2015?
15, my lord, that has been amended, my lord, now.
So there is a procurement policy of
Yes.
2000. Let us see that. I do not know. You see, I do not know whether you can say that this 2015 should be there as 21.
First paragraph, my lord.
Yes.
Well, this one, my lord.
Yes.
Next page, my lord, first paragraph. In preparation of the procurement preference policy, Assam 2015, and procurement preference amendment policy, Assam 2017, the governor of Assam is hereby pleased to announce the.
Okay, and its amendment.
Now, my lord, next page, my lord, next page, one, the definition, my lord, 3.1, my lord. So what is a micro enterprise? It has been defined, my lord. My lord, it says, my lord, micro enterprise means such enterprise where the investment in plant and machinery or equipment does not exceed 1 crore rupees and turnover does not exceed 5 crores as defined by the Ministry of Micro Small and Medium. So, my lord, in the NIT, my lord, 1 year they are saying that your annual turnover should be 11 crores. Whereas the micro enterprise, as per this policy, my lord, it could not exceed 5 crores. So therefore, this NIT is not in conformity with this policy.
Yes, we start under them.
At this point in time, they have to take it further. But if you look at, in the meantime, we look at.
The opening date is kind of Monday. I may,
Now, have you submitted? No, you have got 5 crore.
I may be allowed to file.
Otherwise, what, as state on in the Michigan authority, operating the state has to decide. Unless
The
that's
council, but you are bound by the circular that you have issued. And this is under the statute. You have made it under section 11 of the act. And the rules have been made. It's your rules. You are not following your own rules. And how can a executive instruction override the rules that it is? That's all. It's a very simple issue. I heard Mr. N.J. Datta, learned counsel for the petition, who submits that the petitioners are micro micro
Micro
enterprises, enterprises dealing with government supply of dietary, non-dietary articles in relation to zone 5 of the
Zone 5 or zone 5,
zone 5. Zone 5. Zone 5 gains. Zone 5 gains. For the last many years. Full stop. Full stop. However, full stop. Clause, not clause, that's right.
Clause 4, my lord. Page
Wait. Clause. Nonsense to that, you say. The procurement preference policy, Assam, 2015, and the subsequent Assam procurement preference policy 2021 has been made by the state of Assam in pursuance to section 11 of the Micro, Small and Medium Enterprises, Development Act 2006. The petition has counsel subject that clause 4 of the clause 3.1, 3 bracket 1 of the procurement preference, the Assam procurement preference policy, 2001, hereinafter referred to as the 2001 policy, provides that a micro enterprise means such enterprise where the investment in plant or machinery does not exceed 1 crore rupees and turnover does not exceed 5 crores rupees as defined in the as defined by the Ministry of Micro, Small and Medium Enterprises, Government of India notification dated 1/6/2020. However, by the impugned clause 4.1.2 of the evaluation criteria and methodology in respect of the NIT dated 2/6/25.
Yes, ma'am.
2/6/25, a bidder has to not close for, where is that provision?
That provision is, my lord, additional terms and conditions, page 164, clause 4.
However, in terms of, not that one, huh? Let's say, however, in terms of clause 4 of the additional terms and conditions of the NIT dated 2/6/2025, the tenderers have to submit their minimum average annual turnover for the last 3 years, showing rupees 11 crores on system. The petition has counsel sub that when the 2021 policy provides for a micro enterprise to have a turnover not exceeding rupees 5 crores, there is no justification for a micro enterprise to have an average annual turnover for 3 years at rupees 11 crores. No, you see one thing, but it could be one thing, yeah, average annual turnover. Okay, so for 3 years it should be 11, yeah, 11 crores. uh, if, as such, the petitioner is unable to participate in the tender, in the tender. If you notice, returnable in 3 weeks, Mr. R. Talukdar accepts notice on behalf of all the respondents, all the respondents. This is the matter of when you did. In the interim, the petitioner should be allowed to submit his tender pursuant to the NIT dated 2/6/2025, showing that he has got an average annual turnover for the last 3 years at the rate of rupees 5 crore. It is also made clear that the contract should not be finalized without taking the prior permission of the court.
And EPF like EPF.
In the meantime, we will supply with copies.
Extra copies, please provide. Okay, after some time, we'll have to. Where is he?
That's okay. There is a package for what? So it will it's a small matter. It might take some time. That's it.
Okay, anyway, then we'll hear, we'll carry on, we'll hear him, we'll let him come and clarify.
May I just then submit the compilation that I have prepared? Basically, it is the bid document that I have downloaded along with a clarification along the pages. Now I'll just submit the copy to the other side. Okay.
Why are you giving such a thick note already? We have got, who asked you to give such a thick note?
It's not a note, it's the bid paper, the entire document. Because the entire issue is, in the bid document that we have uploaded, documents are not here. So I downloaded the entire bid document as available in the website. And the front is just a clarification of those points along with the page number. And I gave copy to the other side also, because if they say something is wrong, then they can point out.
Yes,
Now, Lordship has seen that there were 6 points of disqualification as available in page 207 of the epidemic of the health department. Now, out of the 6 points, there were some points where there has been admission
by
from,
them.
from the department itself that these evaluations were wrong. So that therefore indicates that the evaluation process that took place was not a correct one. There has been lacunas in that process, which therefore makes it impediment upon them to go for a re-evaluation. If a lawsuit says the entire gamut of their argument is documents have not been submitted. In almost all the points, apart from only that engineer issue, which we gave a clarification later on, that point number 2, regarding that engineers to be stationed at Assam, for which my argument was because they were a requirement under the conditions of the NIT to submit or provide that list. So on that aspect only, my argument was that since it was not required, when you asked for a clarification, I submitted that we have it. Beyond the other aspect, for all the other 5 points, Lordship had seen that we had submitted the documents. The ground of rejection was documents not submitted. What is now evident during this adjudication is that the documents were submitted, but before this honorable court, they are trying to pick fault in those documents, which does not, however, reflect in the decision-making process of the tender evaluation committee as to be reflected from their minutes. So therefore, in this honorable court, now they are supplementing, they are adding, they are justifying, they are clarifying. But Lordship will have to see what the tender evaluation committee has done on that day, and the test is only that. Whether the grounds as cited are correct or not. The only ground that they have cited is non-submission of documents. Today it is true that documents were submitted. So therefore, the evaluation process was not correct, and therefore that calls for a re-evaluation. Because I will not ask your lordships to enter into a roving and fishing endeavor, though I am grateful that lordship has done that. But then it is ultimately an act for the technical experts to do. What your lordship is looking at is the decision-making process. And is there any fault theory? And in my humble subject subject to correction, there is fault. Because their remarks and what is before a lordship do not tally. Their remarks, no document. Here, documents are available as per admission, but I am finding false theory. So therefore, that is my primary argument. And now on the aspects of certain aspects that my learned friend from the other side, from the private opponent, has stated, there were 2 points basically he has stated. The first point that he has stated was that the audited balance sheets did not contain a particular document. Now, you can see the trading account, there was one page. We were required to submit the audited balance sheets.
That was reason number.
That was region number 1. I'll just take your lordship to that just for a recollection of your lordship. Page 207, if your lordship will come to the affidavit, page 207.
Yes. Peter did not submit average annual turnover.
Yes, Peter did not submit average annual turnover for
So this reasoning has been admitted by by Mr. Gopal.
yes.
That this is wrong. So this is in your
Yes.
favor.
So first of all, no. They then thereafter, the private respondent have also stated that the document might be there. The health department might be saying that the document is
No,
available.
I'm not going into that.
But if you go deep into it, you will find that there is one place missing.
That is the difference. That is the issue to be decided by them.
Yes, yes, yes.
That is the issue to be decided by the technical bid committee.
That amount of
The
dissection.
issue is only with regard to did not submit. Whether it was incomplete or not, we do not know.
Exactly.
They said that it's not submit, but they submitted. Whether it was incomplete, that is another issue. That word incomplete is not there. So I will not go into your thing because you are not the technical committee.
Yes.
So that one vote. But that is not what the technical committee has said. No, you see, we cannot go into that. That is a different thing. That is not an issue. That was taken up by the technical bid committee. If that was an issue, then they would have said it. You see, you cannot supplement whatever decisions have been taken, especially when you are an interested party. You've got no role to play. You are not there. You are not a technical committee member. Correct. That is why your argument on that for failed. For the simple reason that the standing council for the health department has stated that yes, this reasoning number 1 should fail. He said that. He did not say fail, but he said yes, it has been submitted. Maybe, but then your submission, who cares? Your submission on that count, because at the time, the bids were evaluated, technical bids were evaluated. You had no role to play. Then, who are you to say what they were thinking or what they were considering? You do not know. That cannot be accepted. No, you are pointing out something beyond the reasoning given by them. The reason was that, number 1 was that Bidder did not submit average annual person. No. That is in reply to the, that is in reply to the,
That will be another.
that is in reply to the representation. Huh, you made a representation?
Yes, Lord. At
Okay, yes,
two
yes,
hundred
that,
and ten.
yes, wait. That's
Two hundred
correct.
and eleven is the representation.
No, you made a representation and then they clarified.
Yes,
So whether
two hundred and eleven is the representation.
whether that clarification given can be ignored, that is another issue.
Therefore, I have an argument there also. What I'm saying is, after my clarification, now they are taking another point.
Now let us see the clarification given.
Yes, page 210. Of that evidence, 210.
Yes.
Customers got that? In my representation, I did not justify anything. I simply said, I'm submitting the paper, resubmit the paper again. Now, you will see their rejection. From CA, properly addressed and lacks CA signature, making it non-compliant.
Correct.
Now there will be two aspects. There cannot be two re-evaluation. Page 207 is one evaluation. Wherein they do not talk about the CA certificate. They only talk about the annual average turnover for the year 2024.
Yes,
It's not subject.
Clarify by page one, page two.
So when I filed my representation, was there a re-evaluation that culminated into page 210 and the reasonings therein? So in page 210, purportedly, after that new re-evaluation, they came down to only one ground, and the ground now seems to be a different ground. The ground seems to be they are now finding fault with the CS certificate, which they did not find fault on 21-2's initial evaluation. So when the initial evaluation took place, 21-2, to which the authorities now are standing. So as I was saying, so therefore the authorities are today standing up to the evaluation of 21-2, the initial evaluation. Page 207. So thereafter, after I filed my representation, was there a re-evaluation that led to this finding?
Okay, supposing there was a re-evaluation, is there any bar on having a re-evaluation?
No,
There can be no bar.
if there is a re-evaluation, then it culminated to only one reason of
No,
not having the CS certificate.
Re-evaluation only with regard to one.
No, because my representation will also will see,
That we will say.
because my representation.
I know, there's no point going, your case is this. There were 6 reasons, but because of your representation, they've come out with the rejection of your bid only on one ground. And accordingly, the rejection of your bid has now occurred only because of one ground and not 6 grounds. That's it.
So that is my second legal argument. Because what I'm saying is, if they go by this 6th ground, then I have documents to substantiate that it was there. But then if they say, no, we re-evaluated and we came down to only one ground. If that is only one ground, then logic clause 19 provides me that area to provide either the annual average turnover or this CS certificate. But then I would not know. So I would safely submit that probably it is the 21-2 initial evaluation, which is the evaluation, page 207. And therein, you will also see the ground is non-submission of the document. And another aspect is, another ground that they have found fault with is the pass certificate, the pass expedient. So they had said that the contract, the purchase order that we had submitted, the contract paper that we had submitted to indicate our past performance.
It says here, bidder did not submit details of skilled and trained service engineers based at
That is point number 2. Point number two was non-submission of the list of skilled and
No, it is because they got something to do from the skill. Based at the
yes,
based to the
yes. For that, I had showed clause number 12. Clause number 12 says that you shall have. It does not say that you are supposed to provide that list. While for other particular clauses, other requirements, they have said you have to submit, you have to provide.
clause 12, where
Clause 12. Page 196 roughly. Hundred and 96. It says the bidder should have skill and trained service engineer. So my argument therein was that the requirement to submit was not available or was not provided in that particular clause. But whereas for the other document, the specific language was the bidder has to submit, the bidder has to provide. So as a bidder, I will go by the reading as is available in the tender draft copy. So it says the bidder should have skilled and trained service engineers with staff. And since there was no requirement to give a list to that regard, we did not provide a list, but when the clarification was shown, we provided the same. And plus my other argument, yes.
and also then this that proof
Yes, sir.
where there was around 10 of them, 10 or 11, where is that page?
That will also be fine. That yes, page 82 of the compilation that I just did.
So this was a part of your bid document or not, page 82?
Yes, for the part of it.
Then why did you give it? This is for what purpose?
This is for the clause 12. I'll just place that. This is for another clause.
Yesterday you were saying, no, this number 8 is in the 7.
Yeah, it basically covers both the, I'm just placing that document, page 192. 192. Service and support, service and support. Occupancy service and support, page 192. Dedicated toll-free phone numbers for service and support, bidder OEM must have dedicated toll numbers. Then number 2, the second point, service and support, escalation matrix for service support, bidder OEM must provide SQL is a matrix of telephone numbers for service and support. So for service and support, they have otherwise two clauses. One is this clause number 22 and 23, and the other clause is in space 196, which is the clause number 12. So the document at the compilation phase 82 is to meet service and support insofar as clause 22 and 23 is concerned. And clause 12 is basically an additional clause saying that apart from the service and support that you have given, you must also have skilled and trained service engineer based at Assam. So to that regard, my submission is that since you did not ask for submission of the list or for the name, it was not submitted. Rather, on clarification, it was given. And this was not a document that has been sought for as an essential criteria, because Lordship knows. Yes, sir.
Okay, then,
So my argument in that particular clause is that it is not an essential criteria, number one. First of all, the reading of the clause itself would indicate that.
so according to you, clause 12 is not an essential criteria,
So what I'm saying is,
not an essential condition of the terms and conditions.
what I'm saying is,
No, it has to be very clear.
yes, yes.
Is it essential or not essential?
What I'm saying, there will be certain mandatory requirements and certain directory requirements. So the very reading of this clause indicates that submission of the document was not required. Because the language says.
So, Mr.
Number one.
Let's not waste time.
Yeah.
We don't have time. There are a lot of cases I've got to hear. Yours have given enough time. It's a very simple question. When you say mandatory, mandatory means essential.
Yes.
When you say directory, it means ancillary. So it is according to you, not an essential condition. It is an ancillary condition.
Because non-submission of the same.
Whatever, yes, that is what it is.
I justify non-submission of the same.
Right.
And there has to be a clause for that default. The Supreme Court has said what are mandatory clause, if it is not complied with, the tender itself will have a clause as to what happens, the consequence of a default. For this particular clause number 12, there is no clause.
So so this clause, subclause 12 of clause 4
Yes.
is,
A violation
is,
of the
is,
same.
is not mandatory. Is my second question to you is this clause 22 and 23 regarding the service and support, is this mandatory? No,
Whatever clauses.
no, I'm asking you.
Yes.
Is clause 22 and 23 mandatory or not? Now, subclause 12, so you said it is not mandatory. Is subclause 22 and 23 mandatory?
I will have to say the tender terms and conditions. Otherwise, whatever is there has to be complied with. But then we have to see the language of the compliant also. What is the requirement of the
If
language?
it also just answer simply, just give me a simple answer, yes or no. You're running around the bush.
As far
This
as,
is not a love song in a Hindi movie that you love, you run around the bush.
as far as I understand
Please
it,
directly tell me, is this mandatory or not? That's all.
this is the requirement under the NIT tender terms and conditions. No, because the test is what? If
No,
it is
no, so
mandatory,
according to your test,
it
what
has-
is it? Look, don't tell me what the test is. Don't tell me what the test should be. You apply the test. And according to you, is it mandatory or not?
it is a requirement under the NIT and I have complied with that requirement.
Okay, so it is mandatory. So I will not say anything with that.
So mandatory or not, it will be decided later on.
This is the issue that you brought out, Mr. Counselor.
I have to-
I did not ask you whether it was an essential condition of contract, whether it was a mandatory condition of contract. It was you who brought up the subject.
That's to
So since you have brought up the subject, I just wanted to ask you, where do you stand? Are you standing on this side of the fence or you're standing on this side of the fence? Or you're standing on top of the boundary wall? Where? You've got to take a stand.
But certain calls can be deviated by the tendering authority because if it is not mandatory. I am only arguing on that aspect.
Okay.
Otherwise, tender terms and conditions have to be complied with. But certain deviations could have.
So,
been
so,
Or-
according to you, it is mandatory.
Clause 12. It is mandatory to have skilled engineer. Yes, but it was not mandatory to provide the.
It is
list
not, it is not mandatory to provide a list.
provided. with.
Okay.
Because the clause does not specifically
It
say
was mandatory
to have a list, to have engineers based at a sum.
to have engineers paid in stamp, but not mandatory to supply,
So provide the list
to provide, like submit
with the list.
the list of engineers.
Because that is what I understand
Correct.
by reading the language.
Okay,
of the-
that is for subclause 12. What about clause 22 and 23?
22 and 23, this is another requirement. That we
Is
have
it,
to
are
provide,
you required to submit a list?
because it says I have to give the dedicated toll-free number.
So let me ask you, are you required to submit a list?
Yes, because it
List.
specifically says that
So,
toll-free number that will be given.
so 22 and 23 requires a list to be submitted, correct?
Reading would imply that yes, I have to give the phone number. Because it says dedicated toll-free phone numbers. So that means it indicates that I need to submit that list of phone numbers to them. Possibility 23, it says must provide. 23 is must provide.
That's what that's why I'm asking you.
It's must
So
provide.
it's a yes. According to you, it's a yes. That's what I'm asking.
It says bidder OEM must provide. So therefore it's there, must provide.
You're repeating yourself 4
No,
times.
I just did not see this.
Are you trying to convince yourself or I don't know?
So somewhere
It
I
is
was
there
trying
in
to
black and
convince
white.
myself.
Okay, then anything else?
Regarding the past performance, they say that I do not meet that requirement. 50%. 69 cardiac monitors are to be supplied. So I need to meet 50% of the same. 50% would mean around 35.
So you don't have
I
Yeah.
have given that document.
by 50 something or what?
I have given 338, possible C,
330
possible
Page?
C at page 10
of
of,
the,
of this big document compilation.
all these documents are here. Why are you giving another list?
So I gave it there for everyone. So this is the entire part.
Page 10.
Page 10.
Page 10.
Lordship will see. This is the contract. It has been given to the OEM, Mastro Electronics Telecommunication System,
338 pieces.
and the piece is 338. And thereafter, what is the requirement is the invoice.
How much was to be supplied?
I need to supply total 69 in this contract, and the past performance has to be 50%. So therefore, 34 and a half, round up 35.
39 to be supplied.
69 to be supplied.
69 to be supplied.
And 50% is the past performance that I have to do. 50% supply is the past performance or past experience I have.
338 supplied. 338 supplied. 338.
But I have supplied 33. The requirement is therefore 35 only, but I need that.
What machinery is this?
Lordship will see display bottom logic or base.
Yeah.
Display cardiac monitor with defibrillator. Same or similar, also can see that the condition, same or similar. So this is that one, cardiac monitor, and it is the same OEM, Mastros. And the invoice is at page 18. Because the requirement was the contract paper, the purchase order, and the invoice. Okay. So therefore, though an argument was made that the other contract papers were incomplete, this contract paper alone will suffice to meet this particular one.
Well, next,
Next,
bidder did not submit new certificate.
I have already submitted that lawsuit, that the EU certificate was there, and along with there, that extension during the transitional time document, just next to that.
Okay, it had expired.
They say it is expired,
But
but I had produced the document, which was just annexed to this, the next page, wherein that extension was.
Yes. Yes. Okay, please give a, just tell me. So has the council been changed or no?
Yes, Malas, due to the fact that the new set of councils have started appearing forward, we were not informed by, we were not informed about. We,
So Mr. Indranil will not be appearing. What kind of, what is this?
Okay, extreme water got obtained. That case, the reservoir water is already, that was separate. They obtained it in extreme water.
We'll hear you, we'll hear you, we'll hear you. What is happening? Yesterday we heard the matter
yes,
and I was planning to dispose it of today.
we were not informed at all.
Such a thick bunch also. Two files. Two files.
Together,
Basically that in that case, I think there were the EMD, three numbers. Three different
Very.
variations were there. And that they could not, the portal did not accept,
They think that
They
their
said
norm was not accepted.
not accepted to us. Okay, you're there also.
Yes, I am. I'm for the corporation who had to do the.
Okay, okay.
from two occasions, two set of councils have been changed. We are the third, and we are not informed about.
Forget project suffering. I suffered.
Yes, my lord.
I am with you.
This is the reason that we put it today because you all were in a hurry to dispose. That is why after hearing you all at some length, no, not at some length. Today we fixed it. I know, no, not your problem. Your client, he has changed it. And you have not given NOC, they have not asked you for NOC till now.
We are not started now.
We have, it will not look nice if you don't give us.
I'm not also able to find out that council is getting the money.
No, that council is also not the one who has been approached. He's a proxy for a council who is going to be engaged. So everything is in a flux.
I don't know.
Today, we are expecting today. That vacation was high.
I have already checked.
You have just now gone against what your brothers are saying, what your colleagues are saying.
He
From
is the
what?
contractor. I am the tendering
Huh?
issuing authority.
I have, well, he has given, he have been, I have given. them contact to-
They are praying for setting aside the interim order today. You want it next day.
No.
Huh?
I have told him,
Vendor village.
it came out. But might have been-
This is the beauty of being of advocacy. You can argue this side sometimes, this side sometimes. But actually what has happened here, you're arguing the same breath. Only thing is that they wanted it a little earlier. They wanted the vacation to be done today. We'll see after this matter. Might vacate it.
I will find out.
It is not done otherwise.
Then also.
Okay, so according to you, because of that time period between the actual uh, expiry of the validity period and the asking for the extension of the same
They have.
or the revalidation, the period in between would be deemed would require the earlier certificate to be deemed valid,
Invalid, yes.
deemed valid.
Invalid. So therefore, it could not have been rejected on the count, on that count itself. Because
So-
those documents were
So,
also annexed.
Mr. Gogoi, anything to say to that? Nothing.
Our expert also, yesterday, I stayed with them.
Ah,
He said, we might be 40, but
might be possible.
because the people, verification are proper. Instead of clarifying that by writing, they submitted those three documents to us. We submitted to them.
Resubmit. It was already there in the.
We submitted.
You could have asked them for a clarification. You could have asked them, call them and have a clarification. You didn't do it.
That is already available to the authority.
So that query was not proper from our side.
Correct.
He said it was not.
Correct,
proper.
correct.
We have submitted, we are submitting.
So,
I explained to them,
because they were not informed exactly what was the real issue. Because they have said that this document,
Now,
EU part will go on it. Next, bidder did not submit financial standing.
Yes. For that regard, I had shown that the clause is a requirement for only undertaking and the undertaking was very much there.
Did not submit financial standing certificate. Was it submitted? That is the issue.
Yes, Lord. So this is falling from a particular clause. This is coming from a particular clause. That clause,
Clause 3.
also will come to clause 3, yes, page 189. Bidders financial standing. The tender condition says the bidder should not be under liquidation court receiver or
So you submitted an undertaking.
bidder to upload the undertaking. This is the requirement. Bidder to upload undertaking to this effect, which bid. And I have uploaded the undertaking, but in the ground,
No, where does it say upload? Doesn't say upload.
possible see that particular paragraph.
Where? No, where is the tender?
Page
Show me clause 3.
189.
Huh?
Page 189,
189
189.
in the repetition
No, in the affidavit. Also the clause first,
affidavit.
89. Also will come to the affidavit of the health department, page 189.
I got it.
Yes.
Generic, 53 generic.
Here, the language says, therefore, in there, bidder to upload undertaking to this different.
Okay, bidder to upload.
Yes,
Uh-huh.
yes, sir.
Okay, bidder to upload, and he has uploaded it. That
Page
is there.
49 of the compilation.
Okay, I got it.
Yes. So therein also it indicates non-application of fine by the authority. They say certificate not submitted. You yourself have said it. I did
Certificate not
undertake.
submitted.
Yes.
That is not, undertaking is required.
Clause
Undertaking,
is undertaking. I am
Uploaded.
rejected on the ground of non-submission of certificate. Non-application of fine, mechanical approach.
okay. You don't have to run around the tree twice or thrice. Once is enough. Next.
And the last one was that spare parts availability that I had shown that list I had given them.
Spare parts, there, did not submit declaration of spare parts
Spare parts
availability.
availability, and that I had given also at that place.
Okay. But then out there, I think your case was that you did not supply information and the information and material.
Yes. What he was saying is
Etc.
that the material. Now my argument was material should be there for sample. You have not asked me for samples.
No, but what about information? Information will encompass what?
That list was there.
Yes, let us see the list.
That list of spare part.
That in that kind of compilation, the four plus one.
How is it done? Turnover, bidder turnover, past performance, authorization.
On page 81
81 of?
of the compilation that I just gave.
So what do you mean by materials? Materials means he has to supply the samples.
Language of the clause, it says, the seller shall provide material, there's information, etc. pertaining to the spare part.
Pertaining to
Etc.
the-
to the pertaining.
Pertaining to.
Anything like information. Okay. Not a central thing.
And for that regard, I have submitted at page 81 of the compilation the list of spare parts, accessories, and consumables.
Okay.
So non-submission is not there, submission is there. So therefore, if I have the submission, I will not again repeat because understand what I wanted to say. Process was not correct. The evaluation process was not correct, which calls for a re-evaluation.
So any citation, nothing. There's nothing to cite out here.
No, about.
You will have, we will not have.
Actually,
It's all on factual.
because I can produce judgments on non-application of fine arbitrariness.
No.
These are all.
That is,
And there has.
but he's going to provide one or two. He has
Yeah,
to.
Submission of document after the last date of submission.
That I have never done.
What?
That I'm, that's why. Okay.
Let me hear now.
Now, also, from what year I give today, these fellows, out of the six, at least on two counts, that is fellow, that fair part, and fellow this.
Number two.
And that fellow,
Engineer.
yes, engineer part. Why I'm saying is, fellow, engineer part, fellow, this document kindly come to page 192. Just I,
Page 192.
190. 23, clause number 120, 20,
192 of the bunch or the writ petition?
of the written. There is a part of our affidavit of it.
Yes, 192.
Fellow, clause 23 says, yes, service and support, so you see the heading, fellow,
Yes,
service and support.
Yes.
It says, fellow, the bidder OEM must provide escalation metrics of telephone numbers for service support. Now, we will turn to page 196. One 196.
yes.
Clause 12, fellow, clause 15. Same clause again, fellow, service and support added. What we have added is, bidders should have skilled and trained service engineer based at Assam. So in that chart, metrics they have placed, fellow. But in that chart, fellow, the service engineer is not of the bidder. It will have to be read conjoint,
Read together.
read together. So, my lord, 1 ground is enough, my lord, for disqualifying a bidder, my lord. It must be there, my lord, mandatorily required. On this ground, itself, the fiction are likely to be required. Now, my lord, going to the spare part, I have stated, my lord, it is pertaining to the spare part. Sort of information, they can produce the brochures and all that, which they have not provided. And, my lord, one point, my lord, has been raised by the respondent number 5, that, my lord, that there is some flaw in their, my lord, balance.
Just a minute. Happy? Account.
Yes, no, what, my lord, para, not the, my lord, regular para, it's 18, not the para.
Yeah.
But, yesterday, the respondent number 5 pointed out, my lord, in the balance, there's some flaw in the balance. Today, they have not been able to testify or to that, my lord.
That is a different issue.
No, that's the issue, my lord. That's why I'm placing this. That's the part. Not to kindly have a-
No, but that is not the issue taken up by the technical committee, by the technical committee.
When it is pointed out, the honorable court will have to take up. Ultimately, my lord, that's what there are 18. There are 18. In support, my lord, there are 18.
Smiling away. See, I told you.
Yeah. So that's why I said 1 round is enough, but my lord, I want to say.
Yes,
There are 18, may I
yes, yes.
Before we conclude, it is necessary to point out that the High Court was of the opinion that the eligible bidders were not entitled to be either included in the petition filed with the High Court by the ineligible bidder, so and so, or were not entitled to be heard with respect, which is not the appropriate use of the method, such as the present. Now, this is very important, my lord. There are several reasons for this. One of them being that there could be occasion, as in the present appeal, where an eligible bidder could bring to the notice of the owner or employer of the project that the ineligible bidder was ineligible for additional reason or reason that were not within the contemplation of the owner or employer of the project. It was brought to our notice, or you will see the next slide. It was brought to our notice, that is the honorable court notice, by a infrastructure in this appeal that so and so did not have any experience in the construction of a by the segmental construction method, and that the translations of documents in the Mandarin language filed in the High Court were not through English translation. Submissions made the learned council for response infrastructure in this regard are important and could have had a bearing on the decision of the petition filed in the High Court, but since response was for the party. So here, madam, they have pointed out. Though it has escaped the notice of the minor employer or the technical committee member, but my lord, being a minor participant in the tender process, being a bidder, when it is pointed out, my lord, it will have to be taken notice.
So in this case, uh,
The balance sheet, my lord.
what was the subsequent reason given for not accepting the bid of the petitioner?
My lord, here, my lord, our plea was that, my lord, it's, I was trying to page number 211 A. Part of our repetitive method.
211.
The condition says that either they will submit a minor certificate authorized by the certified, chartered accountant regarding their minor turnover, annual turnover of the last three financial years.
Yes.
Or the balance sheet of last three financial years. Now here, my lord, 211A, Lordship will see this document, it has been addressed to one managing director, Assam Medical Services Corporation Limited. And down below, there is no signature of the my lord, chartered accountant. Their contention is that, my lord, since they have got the UDIN number, so their signature is not required. Now, Lordship may turn to the next page, 212. Same petitioner, he has submitted another document. At the top, it says, well, this is a certificate also. It says annual turnover statement of the authorized distributor or dealer. Lordship will see down below in the right hand side corner, my lord. Here signature is there. Here the UDN number is also there. In the left hand side, down below.
Yeah, so
So
what,
here,
what,
my
what,
lord,
what,
I'm saying is, my lord,
no, no, what was he supposed to submit?
he was supposed to submit a certificate.
Certificate for which period?
Yes, for the last three financial years.
Last three financial years.
Page 191,
191.
clause number 19. It is a part of the buyer added with specific terms and conditions. Clause number 19. Bidder turnover criteria. It says the minimum average annual financial turnover of the bidder during the last 3 years ending on 31st of March of the previous financial year should be as indicated in the bid document. Now, documentary evidence in the form of certified audit balance sheet of the relevant period or a certificate from the chartered accountant, cost accountant indicating the turnover details for the relevant period shall be uploaded to the bid. Yes, sir, right. Page number 191. So,
Okay, this is with regard to one.
yes, what? So these two documents, my lord, is very clear that in one document, it has been wrongly addressed and there is no signature of the chartered accountant. Page, my lord,
Of the previous financial year. So this,
so it will start from, my lord, 21, 22, 23, 23, 20.
no, it's, 24. So it's to 21, 22, 22, 23, 23, 24. So out here he has submitted
Page 211A.
1 he has submitted 23, 24 is there.
21, 24 it is there.
But in page 212 it is not there.
No, my lord, that's not the issue. My lord, what I'm saying is it has been addressed to someone else.
Correct.
And my lord, in the down below, there is a signature.
There's no
of the-
signature.
But
There's no
in page,
signature.
my lord, 212, they are saying it's not required, but their own document says it, the chartered accountant number is there, UDN number is there as well as the signature. UDN number is, my lord, so that, my lord, authenticity of the certificate remains. By the UDN number. So, my lord, either, my lord, this particular certificate or, my lord, the balance sheet. Now, my lord, since, my lord, it was found that, my lord, they have submitted the balance sheet, I made a fair submission to the honor court that if either or all, my lord, they have submitted, it is not necessary. Other than on that particular count, they will not be eligible. But, my lord, yesterday it was pointed out. The export says at moment pointed out by eligible bidder. It will have to be, my lord, taken care of. So they have failed to reply regarding the balance sheet. So that if the balance sheet goes, my lord, they will have to rely upon the certificate.
No, and then he was relying upon the trading account. This is the balance sheet.
Balance. Full balance.
He did not submit the balance sheet for 23, 24. Two.
On, again on that count, my lord, the petitioner failed.
That's all?
No, my lord, now one more, this is just one page. People to my lord, not to the kind of it again. These documents regarding that my lord engineer, engineer, that he hails from the state of Assam, was submitted on 24th or 25th. So one judgment in that regard that my lord cannot be submitted subsequent to the date of last date of submission of the bid. 2009, 11, and 15. Page number 9, Sheriff Bill 7.
Yes.
Para 27.
Yes.
Following the aforesaid legal principles laid down by this court, we are of the considered opinion that respondent number 1 was negligent and was not sincere in submitting his pre-qualification documents within the time schedule laid down, despite the fact that here information that there is a time schedule attached to the notice inviting standard. Despite being aware of the said stipulation, he did not submit the required documents within the stipulated date. Pre-qualification documents were received by the respondent number 2 university only after the time schedule was over. The terms and
So that is
conditions
the except, so that is after the last.
cannot be, my lord, subsequently cannot be submitted. Or we cannot accept.
Anything else?
Otherwise, my lord, yes. And my lord, we have stated in our affidavit that document any try to pay 176, 174, the charge.
174.
Yes. Of the affidavit of position. Part. They have given the chart of their disqualification.
Yes.
Well, 174 says, one, my lord, bidder did not submit that chart of given form.
Yes.
Bidder did not submit average annual turnover of financial year 2024. The turnover certificate, the last one, my lord, the turnover certificate was addressed wrongly with no seal and sign of the key. So we have given the ground. Now, my lord, they have
Where is 7?
that I have shown, my lord, page 2118. There is no seal and signature of the key. And it has been wrongly addressed. So there, on this point, my lord, the ground was taken. That, my lord, this particular point, my lord, we have not taken as a ground for cancellation of the, my lord.
This is a different, in your affidavit, it's different. The reasoning is different.
Justification by them in an ever not what is there available in the original binding.
Correct, in the origin, or,
Justification.
that is a different.
So
They cannot do that.
in this regard, I would like to place the judgment, my lord, 2020, 16,
Next level, right?
174. I will place the judgment. So substantiate what they state, my lord, counter date, I will place the judgment. 174, that particular, my lord, regarding the annual, average annual turnover. The turnover certificate was addressed wrongly with no single sign, right?
This is not what you said in the
That's
technical.
why I will reply to that, of course. The document is in the next one, 175.
Yes.
Serial number 2. The bidder did not submit details of skilled and trained service engineers stated at the top. Details of service engineer submitted, but my lord, later, that I placed people to. Then again, my lord, the other EU part, my lord, that certificate now it's not a ground, my lord, so they have satisfied it, go down on the floor. Past experience, my lord, again, my lord, I would say, serial number 3, it was resubmitted without any explanation. And my lord, page 177 regarding spare part. These are the 3 grounds, my lord, now remains. Bidder did not submit declaration on spare part availability. Not submitted any document, that's our ground. Well, of course, these particular grounds are not reflected in the minus. What we will see, my lord, the Silpi construction case, what the Terra will be. 2020, 16 FCC 489.
Yes, 2020.
16 FCC 489.
Yes,
The relation para was para 25.
para,
Para 25.
yes,
May I repeat? That brings us to the most contentious issue as to whether the learned Hindu of the High Court was right in holding that the appealant orders were best in favor without reason. We must remember that we are dealing with purely administrative decisions. These are in the regime of contract. While rejecting the tender, the person or the authority inviting the tender is not required to give reason. Even if it be a state within the meaning of Article 12 of the Constitution. These decisions are neither judicial nor quasi-judicial. If reasons are to be given at every stage, then the commercial activities of the state would go to a grinding halt. The state must be given sufficient leeway in this regard. Respondent number 1 and 2 are entitled to give reasons in the counter affidavit, in the petition which they have done. Oh, my lord, this is my lord, reply to what?
no, but then,
Even then, my lord, now from the documents, it is evident that, my lord, regarding that, my lord, service engineer, they have not done. They have done.
only one thing with the last round that you took. Now the problem arises due to the fact that you have given a reason. It is not that you have not given no reason. You have given a reason. But the reason that you have given, the reason given by the technical committee is not reflected in your affidavit. Your affidavit talks about some other reason.
No,
You see,
the document.
no, the reason, I'll read out your reason. The technical committee says, bidder did not submit average annual turnover. Number 2, bidder did not submit details of sensor. Number 3, bidder did not submit. Now, you see, we have got to go by what it says. Now, if you say that is not a reason, then I don't understand what is reason. Reason has been given. If there was no reason given, then it would have been applicable. The reasons given in your affidavit. But no, but then what about that judgment of the Supreme Court that everyone so many times have used Govardhan Das? Yes. 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 By way of reason, supplemental reason given in the affidavit.
That's why I want to put it in the realm of contract.
In the realm of contract, when no reasons are given. That is why it has said.
But
out
even
there.
then, my lord,
It has said.
even then, my lord,
No, it has
we
said.
decide this.
He is not required to give reason. If there was no reason, okay. But you have given a reason.
No, here, my lord, that financial certificate is not, actually, it's not submitted. This is not a certificate. It's not a certificate. Page 211.
Unfortunately, I cannot know what was in the minds of those technical committee members actually when they said that document not given. Actually, it meant that this
No, I
particular
understand.
thing was not in order.
But my lord, apparently from the record, is the address to something, somebody else, no signature. So this is not a certificate. That's why we said, my lord, that it has not been given. This is not a document. As per our.
So your case of that, even if it is supposed to be considered, there is no signature.
No, it cannot be a certificate. That's why we said not given. Again, they repeated the same thing, they submitted the same thing. And my lord, 2-1 substantiate, my lord, that my lord is required. Yes, certificate, signature is.
You see, next time,
Yes.
you tell your technical committee members.
Yes, yes.
You see,
Yesterday they came, my lord.
we are very simple people. We know only things in yes or no. When they say that the kettle is black, it doesn't mean that the tea that is there always gets spoiled or, it comes out yellow color or something. You see, when the kettle is black, it's black, that's all. You don't go beyond that.
Other than that, I want to basically on the principle of judicial review of.
He has to do justice to his clients also. Yes, Mr. Datta.
I am looking to get more.
Only those two things. One is that 2022-23 balance sheet, and then then the other thing you have said, I think, is that, the performance, the past performance. Past performance, the contract which he has annexed to show his past performance, okay? It is complete on the first page that he annexed, okay? The not remaining part, okay, because he has not the required case parameter without their applied product. Okay, yes, yes. And today, and then it did not have the facility for that, the internal and defibrillation. It is one of the major components for that. Major component. That is the, and in this aspect of the bias, NC, the judgment. The NC for protection, based on paragraph 22. Citation, that, NC project, yesterday, because I have 2022, 661. 22, yes, yes. Paragraph 22. This document has discussed all the cases from Tabakula from paragraph 11. Do we need to discuss all the judgment? 10 and the TCL also, that is the authority, ultimately not paragraph 22. Yes. 22 and 22. The satisfaction, whether a bidder satisfies the tender condition is primarily upon the authority inviting the bid. That authority is aware of the expectations from the tenderer while evaluating the consequence of non-performance. In the tender, in question, there were 15 bidders. Each of the 13 bidders were found to be unresponsive, not satisfying the tender condition. The rich petitioner was one of them. It is not the case of the rich petitioner that action of the technical society was executed by extraneous consideration or was nullified. Therefore, on the same case of fact, defined conclusion can be arrived at a bona fide manner by technical committee. Since the view of the technical committee was not to the liking of the rich petitioner, such decision does not warrant intervention in the grant of contract to a successive bidder. 23. In view of the above judgment, the court that the rich court to refrain itself from imposing its decision over the decision of the employer as to whether or not accept the bid of a tender. The court does not have the expertise to examine the terms and conditions of the present day of economic activities of the state and its limitation should be kept in view. This is these two paragraphs. Where is item one? Yes. That's looking. Okay.
Oh, short reply, because they have got certain issues that I need to answer. First point they are saying is that regarding the turnover, that annual turnover balance sheet. So what they are saying is that,
22, 23.
no,
22, 23, 24.
no, Lordship will see the ground taken by them, 23, 24. If your Lordship will see the compiling that I have given, which is the bid document actually, the bid papers that we have submitted, page 42. The requirement under clause 19 is a audited balance sheet. If you also will see clause 19 is the audited balance sheet, clause 19. They are saying the trading and profit, what account?
The minimum average financial turnover of the bidder during the last period. Documentary evidence in the form of certified audited balance.
Balance sheets. So what is required is the balance sheet.
Correct.
Now Lordship will come to my bid papers, that compilation I gave.
Yes,
At page 40, it starts at 41.
41.
Yes.
Yes.
At page 42, Lordship will see is the balance sheet. This is I have given balance sheet as on 31st March 2024.
Where is that in the writ petition?
In the writ petition, Lordship will see at page 77. The writ petition lordship will find exactly the same thing. I admit, so in a particular financial year, the accounting takes place in various accounts. Profit and loss statement, statement of affairs, trading account, balance sheet. The requirement is the audited balance sheet and the audited balance sheet very much available. They are referring to a trading and loss account. Various accounts are the letters are made by the accountant. Page 71, lordship will come to the of my writ petition. 71 is the balance.
77.
77,
The
yes.
balance
Yes, lordship. This is the balance sheet.
for 23, 24.
Yes, lordship. It is a part of the writ petition.
Okay, that trading and trading, it is a part of the balance.
Huh?
That trading account, that sheet of trading account showing the annual turnover, is a part of the audited balance sheet.
Ah.
Which he submitted in 2021 and 2022. But I don't know, it is purposefully or it is a deliberately or other.
Okay, so this
but
page,
he has-
page 77 is not complete.
Not to the anecdote.
Yeah. So the trading and loss,
Loss is it is
Yeah.
not a.
it's a part of the balance sheet.
Part of the balance sheet.
So my argument is that,
No, is that correct?
no, balance sheet, what is recorded is the balance sheet.
No, I'm not on that.
What is the
You see,
purpose for having that balance?
Another
Because
aspect,
for that,
no, let us be very clear.
the inward turnover required is only one proof. I
No.
think that is the very first.
No,
step.
no, that is not the issue. You see, the issue is
Yes, lord.
whether a balance sheet is trading and loss, what that? Where is that for the other years? For the other years? Balance sheet.
Trading account for the year ended 31st March 2020.
This profit and loss account,
Yes, lord.
is it a part of the balance sheet?
So my understanding is a balance sheet is a different calculation altogether.
No, I'm not talking about that.
Profit and loss is a different calculation.
So a profit and loss account is not a part of the balance sheet according to you.
If I see in the internet, it says, no, a trading account is not a part of the balance sheet.
and
I'll-
For that, again, an accountant will be required. obviously.
page 60.
Because I
Page-
understand as it is,
60.
60.
60 of the DPD. If Lordship is taking up that DPD.
60.
a financial statement will include one of accounts. One of them may be a trading account.
Yes,
profit and loss account.
60.
It is the balance sheet as on 31st of March 2021.
Yes.
And with branch Lordship, page 61, 62, and 63 Lordship.
No, every page is signed
Yes,
separately.
yes, I'm-
Signed separately and completed separately.
That's been complete. And
You know, that's
page 63 is also signed in terms of our report, event dated 4th, is it signed by a chartered accountant? It is audited balance, sheet, part of the audited balance. And next also Lordship, page 65 onward. Balance sheet for the year 31st March 2022. 66
I will ask some, I've got an accountant, they'll come, I'll ask them.
and 68.
But one thing is that if you all can, you see, instead of me asking,
Yeah.
these are simple issues. I think I should be given the correct information with regard. These are simple things which I am going to ask anyway. But if I find one of you all are intentionally misguiding me, then it'll be bad.
no one
Alright.
is because we are not accountants ourselves.
But you all will be knowing, I think you all will be knowing this. I don't think I don't pay income tax only now I started. That's why I'm starting to learn a little bit. So and I don't do business, so I don't know.
The losses in the language, it's an audited balance sheet. And I can show that the balance sheet was there along with the big paper. To that aspect, my submission. Right. They say we have not submitted altogether. My argument is submission is there. They are saying that, no, it should also include the trading and loss account.
Anyway, let me write down. I'll just talk to the
Yes.
accountant. Whether the
Trading account. Trading
whether
account-
the balance sheet,
Trading account for the year. and then-
whether the balance sheet includes profit and loss.
No, no.
Trading,
Trading account.
trading account. Lord.
Trading account for the, of the, trading account of the business, or the
So out here,
Is trading account
According-
part of the balance?
it's trading account by part of the.
yes, full number. If the trading account is not mentioned on the audited balance sheet, what is the purpose for requiring that balance sheet by the account?
I don't know.
One hundred.
No, yes. You see, they want a balance sheet. According to him, he's given the balance sheet. According to you, his balance sheet is not complete. For the simple reason that the trading account has not been annexed. For the 2023-24, though there was a trading accounts annexed along with the 2022 and 22-20, no, 22, 20, 21, 2021 and 2021, 22. So we'll have to see. That's the only simple long and short of it. Now, whether he's correct or you're correct, I'll see. Correct, correct. So for 2 years it is there.
Yeah.
Only thing is for the third year it is there or not, we'd have to see. No, third year also.
2021 is not required here, but here the name.
Yes, that is not required.
But 21, 22,
No, no.
23 and 23, 24.
Ah.
That 22, 23 and 23, 24 is missing.
Okay, for
That
2 years
that
it's
is
missing.
the 11th page, where from annual turnover can be derived from.
Think that we'll see that.
And so the alternate to that is the CS certificate. So I have given a CS certificate also. So let me just make a submission on that.
Yes. Yes, sir, there is not property address.
Phase
Also
200,
does not pay the signature.
Yeah, and let me therefore substitute on that.
That for substantiating, that the audited balance sheet is the 11th page is missing.
Let
From
me,
which that audit
therefore,
turnover can be derived by the.
let me therefore clarify on that aspect also.
Now,
Yes.
So I should not mention now. Okay. Yes, First, clause 19 says either audited balance sheet or the CA certificate, page 211 of the agreement. The certificates are there. I'll just explain by showing the certificate there. It's either or. 211A.
Yes.
Yes, sir. So audited balance sheet also I have submitted. These CS certificates also I have submitted. Now this indicates the financial status. Now, the objection raised by the government is that this is not addressed. This is not addressed to the director. That is one aspect. To that regard, I admit it is not addressed to them. But my argument is that it does not change my status. What is required to be pointed out is my financial status. And I meet the financial status by flying colors because what is required is only 1 crore. And also will see my turnovers. 47 crore, 27 crore, 55 crore, and 43 crore. Requirement is only 1 crore.
Anyway, that is what about the second part of it? That
Yes.
it should be signed by the
Yes.
CA.
Regarding that, Lordship, if I may just place this. The UDI number, what is an UDI number?
No, you see, the thing is that maybe UDI number, but then
So
when
that is
the,
the mandatory requirement by a notification. After 2019, all CA certificates are marked with the TDI number. Lordship has seen nowadays, this internet, we receive all these documents from the bank and everything. It says digital signature or no signature required. And Lordship will see both the documents at page 211 and 212. Because my learned friend was also arguing in one here the CA sign is there, in the other the CA has not signed. First one, the 2019 UDI number is the part of authenticity of a document issued by the CA. So therefore, now Lordship will see the name of the CA. CA Vishal Bothra in 211A. And on the next page, 212, which is another certificate. Yes. 212, Lordship will see that this has been issued by a different CA. CA Sita Ram Jat. He also have a UDN number. Along with that, he has signed. Therefore, two different CAs may adopt different plans, but that does not discredit this document at page 211A, issued by CA Vishal Gupta. This is my signature can be given, no doubt about it, but not getting the signature will not ipso facto make the document invalid or to be a bad document to be rejected because the UCI number is there.
But what happened when the author, the employer, wants a signature?
The-
Whether it can be, it does not say UDIN number, supposing,
Tender terms.
because the tender term, the authority making the tender, he knows that UDN number is there, but he still wants a signature.
But then it has to be there in the NIT terms and conditions. So my submission is that.
Then what
NIT
are
terms and
what does the NIT terms and conditions say? It says, documentary evidence in the form of certified audited balance sheet or a certificate from the chartered accountant.
That's it.
Okay, that's not
Because
say.
signed, it does not
That's
say.
that's it.
It doesn't even say, if I may argue, doesn't say to whom it is to be addressed. That also doesn't say. If I have to argue that.
Yes, no, with the,
It can be nowadays, because nowadays digital documents are there. That is the UTI number. The UDI number. Also, UDI numbers can be verified online, and this is the online verification to authenticate that document. That is why the UDI number, because earlier there were issues of fake signatures, false documents. Therefore, that system of UDI.
anyway, we'll see.
But that will also be kindly see.
What?
That UDI number can be verified online. I just give it to you.
No, that's, I'm not on that.
So on online verification, possible find.
I want to know whether signature has to be given or not. I understand your logic. You are saying that since the number is there, that amounts to giving a signature.
Which can be verified online.
But then whether, okay, is a digital signature and a UDIN number same? Different all. A number only identify the
That's the
CA,
issuance of the document.
the CA.
The issuance, no, the issuance of the document is not, can you see that online proof? Online proof. The logic goes and sees that UDI number, everything is there. What is in that document?
No, so that's what.
So that is therefore, this document, logic, kindly see.
Oh.
If that UDI number is fitted into the website, the entire document comes out, whatever is there, by Sunil Otra, whatever is there. So this is how it has been done. Signature doesn't matter nowadays because the UDI number is the authentic. Signature is basically for what? To
So
authentify.
basically, according to you, the UDIN number is basically signature.
It authenticates the veracity of the document. Signature is to authenticate the veracity of the document. It verifies the document.
I don't know. I don't know. I'm
Therefore, rejecting it on that count could not have been a valid. And the tender terms and conditions.
it
does
says
not
or
specify.
a certificate from the chartered account.
The UDI number is the
Let me find out. Let me find out.
So this will be my counter to the argument on because other points will also.
Okay, I think. Yes.
Deeply obliged, you know. Yes.
What-
Also, another aspect. Also regarding the clear part, just clear part, what was required was the declaration only, the rejection possible CP 207. They had asked for a declaration only, and declaration is available at page 83. Lossy was in the ground of rejection, page 207, last. That took a lot of time, last. There was another ground that I did not submit the spare part list.
Ah.
On what ground I was rejected? Lossy was in the ground of rejection.
But it has to be read in conjunction with some clauses of the tender. It cannot be read just like that.
No, because the reasoning is clear. Last one, bidder did not submit declaration on spare part availability.
Correct. Declaration.
And the declaration is available at page 83 of the bid document, which is a part of the bid document, page 83. So you can just note that on page 83. Second page 83
Page 83 of what?
of the
Of the
compilation
bunch.
that I gave is the bid paper, my bid document. Page 83.
Page 83.
83. Don't you will see the second paragraph? Undertaking. We further undertake that the required spare parts will be available for purchase for at least 10 years from the date of supply. So declaration is there. Now they might find fault with my declaration and say something on that. But saying that no declaration submitted was not correct. Declaration submitted on the availability of spare parts, page 83 of my declaration. So therefore, this ground also is not obliged on.
Hearing concluded, judgment.
Right.
I think the same council. We have to write. Mr. A. Sharma, the fund for the correction, we go for the department. Mr. P. That's it. Okay. Put it up. Next. Huh? Who is the council? MP Bora?
For someone else. The councils are missing it, they think we be. Document record that's in another set of councils are prepared.
Okay, in this item 10,
Both one.
item 10 and 11, Mr. A. Sharma submits that he has been requested by Mr. M. K. Bora to ask for adjournment in as much as Mr. M. K. Bora has now been engaged by the petitioner. Mr. I. Chowdhury, Learned Senior Counsel for the petitioner submits that as the earlier set of councils have been as the new council has been engaged, the earlier set of councils, that is Mr. T. Das, R. Chauhan, and Mr. R. Das. There are a lot, in 11, there are a lot of them. In Ahmed, all that is there also. Okay, should be deleted as counsel for the petitioner from, for the petitioner, huh? Okay. Mr. A. Sharma appearing for,
Respondent number,
just say the party name.
Assam Plains Corporation.
Assam Plains Tribe Corporation Limited, Mr. R. Dar for point number 1 and 2, and Mr. K. P. Patak for the point number 8. Submit that this is the second time, third time. Third time it has been changed. Council. That's what, second time it has been changed. The second time, the councils have been changed by the petitioner after an interim order has been passed by this court in WPC 732 of 2025. Give me the other item 11.
What has happened? That order was passed on 11/2/2025. By that day, on 31/2025, the letter of award had already been issued. I had already submitted my performance, but that was not placed before the order. The order that was issued, the interim order was not finalizing it. Otherwise, also that has no effect. So by that time,
So they are working.
I have not been allowed to work by the department because of this order. So that clarification is provided by a lordship. Lordship has the order at 11/2/2025. Last,
Okay, right, registry to accordingly, strike off the names of the causes for the petitioners. That is Mr. T. Das, R. Chauhan and Mr. R. Das, huh? Then, Mr. K. P. Pathak, the learned counsel for the respondent number
8.
8 submits them. While the interim order directing the respondents not to issue a work order has been passed on 11/2/2025, comma. The, what,
Notice, the letter of award and notice
the letter of award and notice to proceed with the work.
Yes.
Had been issued on
31/2025.
13/1/2025.
I've also submitted my performance system.
Gustav. Further, the petitioner had also submitted, the respondent number 5, 8 had submitted his performance security on
31/2025.
31 30/01, 2025. However, the said facts had not been brought to the notice of the court, of this court. When? Why next week? Why not tomorrow?
Go to the brief. And better. Are they not?
Release the matter on Tuesday, on which date? The question as to whether the interim order should continue will be decided. April. Now also later, whenever, now also you can be no problem.
Lordship, as your lordship desired last time.
Yes,
So, list of dates have been put. So this will make the whole thing, because there are some factual issues. That's to be approved. The detailed list of dates, lordship will get all the detailed, factual stuff in this, list of dates. I have submitted a copy of this. So basically, lordship, this is an application, this petition has been filed against the interim order, which has been passed in an application under 33C2. So lordship is aware that
33C2.
33C2. So 33C2, lordship, I'll just take a lordship, 33C2. If it. Lordship, party.
Yes.
Where any workman is entitled to receive from the employer any money or any benefit which is capable of being computed in terms of money, and if any question arises as to the amount of money due or as to the amount at which such benefit should be computed, then the question may be subject to any rules that may be made under this act, be decided by such labor code as may be specified in this behalf by the appropriate government within so and so, provided, consequently the provision, provided where the presiding officer of labor code considers his fiduciary expedient to do so, he may or reasons be recorded in writing extend to such period of such further period as may it. So lordship, where what is in my lordship understanding, and like what Supreme Court has also said in many other cases. So labor code is there to compute the amount on a pre-adjudicated dispute. Whether when this dispute is already adjudicated, only thing remains that what was the amount that has to be computed, he has the jurisdiction. Now, in this case, lordship, in this case, what has happened is, lordship, there was an order from the labor court. Labor court said that this closure was not as per 25O of this industrial dispute. So on that particular date, they were part of the organization. They were treated as employee. So on that basis, he is left.
What did it 25?
25 was lordship, whether that unit was closed as per law, because that industrial tribunal has come to the finding that this was not as per the 25 lordship. Precisely lordship, it will be 25/06. Where no application. As a lordship body. Where no application for permission under subsection 1 is made within the period specified therein, or where the permission for closure has been refused, the closure of the undertaking shall be deemed to be illegal from the date of closure, and the workman shall be entitled to all benefits under any law for a time being enforced, as if the undertaking had not been closed down. So this was held by the industrial tribunal. Industrial tribunal said, because lots of remembers that this.
I don't remember at all what has happened. When did we last have? So many cases we have heard. I don't
So
remember
that's why
what.
lordship, that list of dates will be important. You know.
Please,
List of dates.
please don't have that wrong view that I still remember. I don't remember anything because that was a long tough time.
My pleasure to read it again. You know. Take it.
Oh,
If your lordship finally takes this list of dates that also will happen.
yeah.
Lordship, what has happened is that 1960, the Assam Spark Steel Mill was established. 90, first mill, lordship. Then like 96, the mill was closed by the management for certain unavoidable reasons. Then 28/10/2004, Labor and Employment Department and Government of Assam by notification 58/1004 referred the matter to industry.
For what purpose?
For purpose of resolving issues. Because they were not paid any wages from 1996. Because it was closed down by the management, but no wages were on,
No wages, no wages.
no wages were. No salaries were paid from 1996,
Which month?
from 1996.
January 1st.
That lordship, I'll have to see like that is there in the of the lordship. I think, you know, but the actual stuff of here. Then lordship, in 15 to 2006 lordship, is important date. The notification of the 15 to 2006 regarding DRS scheme, what DRS scheme was brought out by the government of Assam for many public.
Which page is this?
This is lordship there in.
What page is that? 2004.
The page numbers also I haven't given. I'll refer to the page numbers when.
to read, to understand what is being involved, the purpose.
Then Lordship, I'll have to go through that, take your Lordship to that. Judgment award, Lordship.
No, you take me to this 2004 notification, what does it say?
Yes, Lord. No, page 22, Lordship, page 22.
Home notification.
Page 22. You can- This notification is not there on the board.
It's not there.
Yes, notification is not there, but like the reference is there in the award.
Okay.
Page 22 here.
Yes.
That last paragraph, Lordship, first paragraph, Lordship,
Yes.
first paragraph, finding no other alternative, has the Lordship got it? Finding no other alternative, the union approached government wide an application dated so and so under section 10(2) of the Industrial Dispute Act 1947 to intervene in the matter, and government was pleased to refer the case for adjudication to the court by notification dated 28/10. So matter was referred to the industrial council. Now, Lordship,
You have to come page 20, notification function of the.
Page 20.
The award itself, right, for it. You might have some mistaken error, date. The government,
there are two issues they have referred.
28/1/2004. Should be. Here, 28
2004.
award, big notification is clear. Okay,
It is different.
award itself. We go through this notification, it will be forty-five.
So this is the same one, 28. The page 20.
20. That's what the people are.
Notification number is given and the issues have been given. That notification is not quoted there.
That is the notification.
For clarifying this is not a notification. This is the only the quoting. These are issues which has been sent to them that has been reflected here. So it is not a notification. The
Thank you.
reference is there.
Let him have.
Now, Lordship, in between, Lordship, what has happened is that the DRS given in 2006. I'll just give Lordship a summary of the facts, Lordship. Then Lordship, I'll take the Lordship. Relevant portion. Okay, Lordship.
No, you see, if you can give me the paginate, because I'd like to. If he also what it is about. Otherwise, again, I have to look for the pages myself.
I'll do that. Lord. I'll prepare the pages. Because Lordship, I have prepared this list of this from the record only from.
Correct, that's what.
I'll give the dates, sir. I'll give the page. Factual part, Lordship. Now the issue, Lordship, I'll take I'll make it short, Lordship, because the issue is not fake. There are two issues. First is like whether this government has issued a notification saying that this unit is closed from 31/3/2007. But prior to this industrial tribunal court has passed out. Prior to this. So the issue is whether issue is the government has declared this unit officially as closed from 31/3/2007.
2007.
2007. 31/3/2007.
But that is not an issue anywhere.
No, not that, because that issue was not adjudicated locally. That was the problem in this case. That is why. So this, whether this, now this calculation that they have made, computation they have made in 2014, December of 2014. On what basis they have made this calculation, there is the.
You said that as per your list, you said that the mill was closed in 1996.
Yeah, 1996, unofficially it was closed down. The no work was
Officially closed in 2007.
70.
Now, where is the 2007 notice?
2007 notification is. The Lordship, can you have a look at page 36? Annex section. One second, Lordship, my apologies, Lordship, that is not a particular page. Actually, that has not been also brought on record. The lower court records have been, because that is not, while filing this, those things were not, and it's with this, recapitulation. That was the point. Reference is there, but like this, particular notifications.
Yes, exhibit two of the law talking about.
That's the notification.
Yes, yes, that will not find that page article.
The reference is
Yeah,
there.
yeah, exhibit in evidence. Paragraph 3, subparagraph 2. Eight, artistic of the read petition. That is the one to say.
Okay. Zero floor with effect from
31/3/2007.
10, 8/10/2007. Right now, you're just make a note of exhibit 2. That I am find it out. Correct.
with close from 31/3/2007.
So with effect from,
No, with effect from 31/3.
Yes, it was issued later on, Lordship. In fact, it was issued on
It was issued on 18
Oh,
ten,
8/8/10.
with effective effect.
So, like Lordship, this was closed after the opinion of award of the industrial tribunal. The industrial tribunal passed the order on 27 March 2007.
so you're looking find that page 20. Page 20,
Listen,
27 March.
in 2000. So why has the tribunal said that why has it declared the closure of the mill as violative of section 25?
Because Lordship, there was no prior notice was given to the employer. Nothing has been stated. Government has told.
And there was no official document.
Official. That is one. That was the reason. I say that this is in violation of 25. Then Lordship, what has happened is that this notification of closure has come. Then what this workers did, like they filed this application under 33C. Because government was not paying it.
That is 3C to the,
labor code.
when did they file this 36?
This was filed on 3/3/2008. I'll give the reference pages also with it. I have checked it also there from the record. I'll give the reference to you.
For payment of wages.
For whatever just the tribunal is whole, that held that, I mean, from 1996, they were not paid any.
From that period.
From that period, it should be paid, because at that point of time, they were deemed to be in service. They were working. Now, let's say, 21/8/2008, there was a discussion happened. The minutes of discussion between managing director, SS so, and the representatives of Assam's Farm Youth Workers Union on AITC in the meeting, amongst other, the representatives of the union expressed their full cooperation with the government for implementation of the schemes as known by the government. So this is their project. This will actually
Implementation of which scheme? The VRS scheme.
VRS. VRS.
So VRS scheme came into effect in 2006.
2006. Now, Lord, see, what another date, Lord, see, what second 12/2008, the minutes of discussion between managing directors and so were in the meeting, amongst others, they presented to the Union Express that Union was with the management. The whole process leading to the implementation of one taken to be closed by establishment of South Fund Limited. The Union assured once again that in such event, Union shall be with the management and be agreed to dispose the payment at the early date of the developer program. This is also minded, this is there on record. I'll
This
place it.
is from 96.
Yes, 96. And one more thing, one very important thing, that they have not challenged the closure of the, as far as the date is concerned, they have not taken. Which
So
date?
that notification has not been carried.
Not taken. Because
That notification of 2007.
yes, it was not taken. It was the closure of the mill, it was not taken. So now, Lord,
That has finished.
no, on the very two things. What is happening? While this is into the application of state, some issues were framed by the labor. And in those, during that process, also lot of things happened. Things like lot of VRS scheme, the whole amount of VRS amount, what the VRS amount, the notification lordship gives, whatever will be paid to the employees. That has been given. They will be paid all the wages, pending wages.
And the
salary.
VRS scheme will be applicable from when?
It will be applicable from the date of the notification. From 2006, it has come, and they have been given benefit of ROP also. The device scale has come, that has been also given. They have been paid ex gratia also. Now, look, these things were there, these materials were before this, before the labor. Now, labor code without, like, talking anything on the VRS, they have not, nothing has been said. What they have done, they have said it for computing. Now, Lordship will see whether under 33C2, some new developments are coming. Whether those without indicating on all those things, whether 33C2 application can be stored. Now, one very important thing in between, Lordship, that commissioner has been appointed. Now, commissioner, what is the commissioner's report? Lordship, may kindly have a look.
Okay.
Lordship, may kindly directly come to page 72. Page 71 is the summary of report parts. Page 70.
Okay.
So serial number 6 here, Lordship. Top of the page here.
Yes.
Payment made by the management terms as VRS payment to the employees as per data provided and cross-verified by the union has been deducted by me from the claim admissible to the employees, which the honorable court may decide if the same may be allowed as deduction or otherwise. This issue was sent back to the labor court. Then Lordship may come to the bottom part.
Yes.
Bottom Lordship will see that that 3 paragraph Lordship. However, Lordship, there was always a stand from the management that it should be calculated till 31/3/2007, not beyond that, because the company is already closed. They cannot be paid for not working. So here, Lordship, what has been stated, however, the management has objected to the use of above process of calculation and has
Where are you reading which page?
page 70.
Yes.
At the bottom 3 paragraphs.
Yes.
However, the management has objected to use of the above process of calculation and has maintained that the calculation ought to have been up to 33/3/2007 and not up to 31/12/2013, since the mill was closed with effect from 31/2007 as per
What is the issue that you want to, what is your grievance?
lots of grievance is that this amount, whatever they should have been paid in 33/2007 has already been paid. As for the other issues of concern, PRS, because in PRS, in addition to their wages and all other due, we have paid extra gratia also to them. And that is not disputed, Lord. That is, we have already paid them. Now, he has calculated it till 2014 on what basis?
Who has kept?
The commissioner has calculated and labor court has passed an order on this, basis of this. No, Lordship, that last paragraph, Lordship, may kindly have a look, the commissioner's report.
No, but why did the commissioner calculate? Why? On what?
The commissioner was appointed by the labor court to compute whatever the wage that.
But that, the earlier labor court order has been quite, that is under 33C.
It is the earlier work on under except that. Now this commissioner has,
No, this 33C has been submitted by the respondent when?
yeah, 33C has been submitted by the. Employee.
Yes, when?
They have, around 30. 3,008. Because Lordship, there were talks were going on for settlement of the team. PRS scheme also came into play. I'll take a lot to all the detail. I mean, where is the notification has been set up by the government for bringing this organized also under PRS scheme.
No, if the VRS scheme had had been implemented in 2006, and the order of the labor court had been made when? On 11/2.
Yes.
Oh. Award made when? What?
The award was on this 27.
27/3. So till 27/3, you should have been paid. After that, VRS only, what they do?
Lots of impact. Because not the PRS scheme was for around 14-15 public enterprises of people. So there was some loan taken to the center. And from that loan, the amount was paid. So amount was paid during 2008. Yeah. So they have accepted this amount. All these amount, PRS amount of that,
They have accepted.
they have accepted it without any objection.
Then?
Now they are saying they need something more. So they have become little bit, I don't know.
DD.
Yes, also, I mean, they have been paid the, once you accept the VRS, how can you go for some
Correct,
other claim?
correct.
You can't do that. So this aspect was not adjudicated, nowhere it was adjudicated. So
So, okay. So let us see the commissioner's report.
Commissioner's report, also may kindly see that last paragraph, which is very important, Lordship. He has also, underscored it. The learned court may decide the cutoff date to be followed.
Where, page?
Page 72. Lordship. The bottom paragraph,
Where?
small paragraph. Page 7.
Yes, yes.
The learned court may decide the cutoff date to be followed. As from the reading of the order, so and so, this reads under so and so, the closure is not specified. I don't know where he has come this, but it was left for the court to be decided. The closure. Now, who can decide? And now Lordship may kindly come to the impugn order. What the impugn order has. What it says. Page 113.
Yes.
The case is posted for order will pass so and so, but the first paragraph we can see. Yeah, it was also directed that the opposite parties should pay the dues already ordered in the award, and all dues to be paid to the union as well as members. The salary benefits, pensionary benefit going to maybe, and retired benefit, and other benefits case may be in case of lack of employees, the benefits could be paid to the years of 24. It was also ordered that how much dues paid and what to be paid for that. There need to be computed, and therefore court was pleased to appoint the commissioner of computation. Accordingly, after hearing the parties, court was pleased to appoint so chartered accountant as commissioner by dated 9/2013. After verification of employees, employment data of the employees such as date of joining service, date of retirement, death, and resignation from service with available service records of the employees, commissioner has concluded that the amount employees of Smart Milk Limited, Dagirot, and submitted his report on CD on 4/2015. So 2015, the report was submitted. Prior to this, one report was submitted, then called for the objection.
So let's see it.
Then I have gone through the report of the commission. It appears that the commissioner has shown in his report, total payable amount to the employees is rupees 64 crores 76 lakhs 30,000 so and so. amount already paid, 31 crores, 59 lakhs, 54, so and so. And balance amount to be paid to the employees is 33 crores, 16 lakhs, 83,000, so and so. And submitted his report in detail covering up to 31/12/2014 as per the order of the court dated 18/7/13. The learned representative union as well as learned counsel for opposite parties have already signature on the report of the commissioner in the provision of law. So this issue was not what we did take.
No, so where is the report of the commissioner?
So we report the commissioner is that this one was I was reading that starts from page.
This is only an extract. Where is the report as such?
The report is this is part of the report. The report starts from page 63.
63 to,
63 till 112.
but what is the final decision taken
So
by?
final decision is this, Buddha, that's what I was reading here, that summary of conclusion, summary report, page 71. He has done this calculation, how he has done this calculation, all these things have been paid. Then this is the summary report he has written, page 71. So what philosophy I am trying to drive in is that his issues were kept open. And whether under 33C2 application, that can be, that this kind of order can be passed, whether the level court has to agree with the Supreme Court said no. That has to be a pre-adjudicated dispute.
No, but what is the commissioner stated? I don't understand. I'm not getting it. What is it stated? Long and short, in 2 lines, what has it stated?
Which line of that?
What has it basically stated?
So he,
Short.
Lordship, he has given all the chart, how he has prepared the chart.
So what is the import of the chart? What does it say?
He has, Lordship will see that there are.
No, without reading it, just tell me what does it say?
He said only that till 2040, December, I mean, this employer has to pay the.
Page 23 is gave the party.
Huh?
Page 23 of the retribution.
23.
He gives all the details. All details. Specific pay.
No, so what has he said that he should be given, they
Yes,
should be
yes,
given certain pay? But the issue is, when the VRS has been taken by you already. VRS has been taken by you, huh? Not taken.
One issue is that there was a closure.
So yes,
Closure. And there is an order of the High Court also that you cannot challenge this case. My friend.
correct.
No, that is where I come.
I did not, let him argue.
No, just tell me short. So the closure is
Like, there is an order from the High Court itself that you cannot challenge the closure. This is very much. So we have not challenged it. Closure. There are two concepts here. One is closure and other is retain. Now, whether all this, though the establishment was closed, in the right last occasion, your lordship asked this thing. Though this establishment was closed, whether the concerned employee, all the concerned employees were retained. That is the only simple. If employee concerns are retained on the date, they are not entitled to anything beyond the date of retention. Till the date of retention, they are entitled. Beyond the date of retention, they are not entitled. Now, what is the retention? Let us close all this. Sorry. Now, what is the retrenchment? Retrenchment is a mode of termination of a service other than service retirement, voluntary retirement, or retirement in course of a discipline. Yeah, that apart, any other retrenchment, any other termination is called retrenchment. That is the retrenchment simplicity.
if a person is not retired on attaining age of propriety, or if a person is not medically incapacitated, or a person has not been terminated or dismissed or removed from the service, but he has lost his job, that kind of termination of service is problem. Now, there is a procedural support in the Industrial Dispute Act. Because it is not a stigma, it is not for his fault. The procedural safeguard is that you must pay some compensation for the purpose of treatment. For the purpose of dismissal, you did not pay any compensation. For the purpose of removal, you did not pay any compensation. But for the purpose of replacement, you have to pay some compensation. So, there are two modes of payment of funds. If there is in any establishment, the employer employs more than 100 workers, there is a one kind of profit. And if the employer employed less than 100 workers, there is another profit. So for our establishment is concerned, is an establishment where it is say about 330 workers. So for that purpose, there is a procedure. That here of my career notice, that procedure is contained as section 25A. 2-1.
No, you see one.
I just do this. Section 25A. So for closure is concerned, it is contained in section 25O. So for retrenchment is concerned, it is contained in section 25A.
N.
N for
Nagaland.
Nagaland. So, this section 25 contains 7 clauses. 7 clauses. Clause 1, 2, 3, 4, 5. Clause 1 is that every employee who starts with a note, you see, you are going to pay. If you don't serve a notice, you have to pay notice fee for a period of 3 months. So let us get by this. Then I think,
Whether the replacement issue was there before,
yes, sir.
there was nothing on that. But now, from where
Let
we
him
are
argue,
working on this?
then I will clear it. Just for clarification.
Yes. Yes. Yes.
So let us start from the very beginning. Section 200.
Second,
200. There is retrenchment.
200.
200. Of the industry. Section 2.
Section 2 I've got. I'm not finding the 00.
After railway company O, 2O is railway company, 200 is retrenchment. And 2N is public utility service. N is public utility service.
Oh, yes. Okay, 00, yes. Yes.
That's it. Retrenchment means the termination by the employer of the service of a workman for any reason whatsoever. That is very much important. For any reason whatsoever, otherwise than, this is also important. Otherwise than as a punishment inflicted by way of disciplinary act. Termination, not by means of punishment. Punishment. But these two things, this is very important, A and B. But does not include voluntary retirement of the work.
Correct, correct, I thought it.
And the retirement of the worker. Next. Now let us come to close up. Definition of close up. The closer two double C,
Two double,
C, C and C.
yes,
Closure means permanent closing down of a place of employment, a place of employment.
yes,
Place of employment or part there.
yes,
So due to closing down of an establishment, employee, concerned employee shall lose their employment.
they do the employment.
Less than that, if it is whole, then all-
So it has been closed.
it has been closed.
It has been closed with effect from,
Anyway, I'm coming to that part.
yes,
They lose their employment.
yes,
So their service has been terminated.
impliedly,
Yes. Yeah,
impliedly, impliedly retrenched.
So there's been part terminated. What kind of terminated? It is not by way of punishment. It is not by way of voluntary retirement.
Is by way of retrenchment.
It is not by way of retirement.
Why? Why will it not be retrenchment?
It is only by way of retrenchment.
That is what I'm saying, by way of retrenchment.
Yeah, definitely. It will be by way of retrenchment. So, when an employer, when a worker loses his job or his retrenchment, there are certain procedural steps. That is to be clear in mind. It is clear people interpret. Now, there are two procedural steps. One, contemplated under section 25A.
Yes,
And other contemplated under section 25A. More or less both are same. Only difference is that section 25A will be applicable to an establishment where less than 100 workmen are. And section 25A will be applicable where the employees are working on more than one. So let us come to section. Our case will be
25A.
Our case will be 25N, but
N.
N. But let us, for our clarification, let us go through 25F,
L,
F as well as F.
F and N.
F and F. So we are not under F, we are N. Now, your lordship come to 25N. Without going through any judgment, Lord, I'm just reading the provision. 25F. Okay. 25F.
Yes.
Now here, you have to mention, my condition precedent is very much important. The word condition precedent and what is the consequence of non-following the condition precedent, that will be very much important. Condition precedent to retrenchment of workmen. Here, no workman employed in any industry who has been in continuous service for not less than 1 year under an employer shall be retrenched by that employer until, very important, until the workman has been given 1 month notice in writing indicating the reason for retrenchment and the period of notice has expired, or the workman has been paid in lieu of such notice wages for the period of notice. Second, that is retrenchment compensation. The workman has been paid at the time of retrenchment compensation which shall be equivalent to 15 days average pay for every completed years of continuous service or any part thereof in excess of 6 months. C. Notice prescribed, it is not very much important, till then, notice in prescribed manner is served by the appropriate government or any authority may be specified by the appropriate government by notification in the official thing. This is for section 25. Section 25 is a very simple. Only you have to give notice for 1 month. If you don't give the notice for 1 month, you have to pay notice fee. And apart from this payment, you have to pay retrenchment compensation. And the retrenchment compensation will be computed on the basis of 15-day wages for every completion of the service. Now you are, and this is contained in chapter 5A. Your Lordship may write it down. Your Lordship will find this is contained in chapter 5A, where less than 100 words are writing.
Okay.
Now your Lordship come to chapter 5B.
Yes.
Five B. What is chapter 5B?
Yes, yes.
Here, special provisions relating to layoff, retrenchment, and closure. There is special provision. Layoff, retrenchment, and closure in certain establishments. So what are those establishments? Let us read 525A. The provisions of this chapter shall apply to an industrial establishment.
25? Okay, what?
Where this chapter 5B will be applicable. So less than 100 workers, more than 100 workers. 5B will be applied.
Yes, yes.
The provisions of this chapter shall apply to an industrial establishment not being an establishment of a seasonal character or in which work is performed only intermittently, in which not less than 100 workmen were 100 and as per working day for the preceding 12 months. So more than 100 more workmen. Now your Lordship come to section 25 O and N.
Yes.
25 N and N. I have prepared a note also, a very big one. All I cannot clear this note. Let me go to that one. Okay. Now, 25N.
Yes.
Right.
Yes, yes, please.
Should I read the entire section? Or
Yes, yes. Why not?
For time, for the sake of convenience of time. No workman. I'll be
Yes,
very,
yes.
it will be convenient if I read the entire section. Condition precedent to retrenchment of workmen. Here, clause 1. No workman employed in any industrial establishment to which this chapter applies, who has been continuous service for not less than 1 year as an employer shall be retained by an employer until, more or less same content of 25F.
Yes.
Only difference here.
3
A,
months.
the
3 months.
workman has given 3 months notice.
Yes.
In section 25, 1 month notice.
Yes, yes.
This is the only difference. 3 month notice in writing indicating the reason, let us keep it off. Achha. Second difference is there. B. prior permission of the appropriate government. In section 25, no such
Correct.
permission of the appropriate government or such authority as may be specified. So the gateway you can apply to the appropriate government or appropriate government if authorized any authority, then you can approach to that authority. Prior permission of the appropriate government or such authority as may be specified by that government by notification in the official gazette, hereinafter in this section referred to as the specified authority, has been obtained on application made in this regard. So, in order to retain a workman who is working in an establishment where more than 100 workmen are employed, you have to apply for the permission. That is not required in section 25F.
So what do you want to say? What do you want to say?
Only after due compliance, that will take away, you'll have to come to subsection 7. of
Then-
it. That will give some indicate. Where no application for permission under subsection 1 is made, or where permission for retrenchment has been refused, such retrenchment shall be deemed to be illegal on the date on which the notice of retrenchment was given to the workman, and the workman shall be entitled to the benefit under any law. That is when the workman shall be entitled to all benefits. That is very much important. All benefits under any law or the time being in force, as if no notice had been given to him. So these are very, very important to comply with the conditions.
Now, but you see, maybe it is sometimes the law does not cover all eventually. So what happens now in this case?
I will refer on what you shall take that.
No, before that, you have to answer my question. Now the question is out here, the mill has closed. That is not good. You are taking voluntary retirement?
No,
No.
no. That is very right.
They
Huh?
have taken volunteer, make some record.
Okay, let him put it.
No, you see, the issue is this. Once you have
How a voluntary is a question of voluntary retirement come up after closure. When you have closed.
No, you have, the issue is whether it is right or wrong. I'm not on that issue. I'm on the issue of whether you have taken the benefits of the voluntary retirement.
We are entitled to have our all emoluments, wages from 1996.
No, that is a different aspect. What I am asking you right now is, have you taken the benefit of the voluntary retirement scheme?
No. A category statement.
And
The
that-
voluntary retirement, if a person an employee has to voluntarily agree to it. It shall be thrust upon him. You have offered a voluntary scheme.
Okay. No, I understand that it cannot be thrust upon.
Thrust upon him.
The issue is,
I am in one thing is what way a lot of anxiety is that. Yeah, that first of all, we are entitled to have our emoluments or wages since 1996.
that you will see, that is a different issue. From 1996 till the date you are taking your voluntary retirement.
Now, from 1996 till the date when my retreat, I was retained. One thing.
No,
And one thing.
You see, everything cannot be done as per the law of that time. For the simple reason that all the problems in the world are not thought of when a certain statute was made. That is why we have a living constitution, thereby meaning that all the laws that go from the constitution is a living law, and it has to change with the time. It cannot remain static. And also, all types of problems, all types of issues are not taken into consideration while making a law. Because
all of that.
No one is perfect.
Now, we have to
Yeah.
adjust ourselves with
Yes.
the situation.
Yes,
But in this, what you are want to say, is that we have to adjust ourselves with the privilege.
Correct, correct. Now,
That
so
is the
my,
thing.
so my question to you is, you are saying that you are not taking the benefit of the VRS.
Yes.
The other side,
Some of the employees, one thing, some of the employees have, what? Sorry.
so the thing is
Some
that,
of the employees have accepted volunteerism. Not all.
so now we have to see
And
whether,
that is discussed in the judgment itself.
Mr. Kaushal,
Yes, sorry.
let me, let me put my queries to you.
I know.
It has to be a two-way traffic. So my question is, now, how do we, according to him, everyone is being given,
According to
everyone is given. So,
With the commissioner's report also.
so if everyone is, we'll have to see first of all, if everyone is given the VRS. Now, if everyone is given the VRS, then the issue of continuing payment of their wages after they have been given the VRS does not arise. You cannot pay more. That's why even you will accept that. I mean, you will accept that also. Only problem is we have to see whether all the petitioners or respondents have been taken. The workmen are getting the VRS. That's all, first of all. Then we will see with regard to the retrenchment, if it, even if it's not done, as per the award paid, the wages would have to be paid till the time the VRS was given. And probably the provisions of 24O, insofar as 24N, insofar as that 3 month notice and 3 month notice would have to be
and retention compensation.
and retrenchment compensation. Is it there here? Retrenchment compensation? Is it here? Yes. Where? 825 and where is it?
25 N. Somewhere, it is somewhere there. Anyway, it's provided.
So now I just want to clarify one thing only. I want one thing clarified as to whether the workmen are all getting VRS or not. Yeah. Fine. So now according to me, what I find, prima facie,
Yes,
not a fine, is that till the date they're getting their VRS, they should be given their wages as per the award and their retrenchment, and they should be deemed retrenchment because now there's no point of issuing notice now. After the VRS, there's no point. So the only thing is that they'll be entitled to the 3 month notice. Yeah. 3 month notice. And, but I do not know if they'll be entitled to 3 months notice now because they're getting VRS, which that might not. But that retrenchment compensation, if it is provided in 25N, as has been provided in 25K,
N.
KK, that 1 month.
No, you have
25F, 25F,
N. F.
FF. Whether there is a similar provision here, I don't know. Then that would have to be provided. Jeff, what do you say to that?
Let him argue that. I will get
No,
one judgment.
I want to clarify my
No,
doubt.
sorry.
Lordship, that PRS scheme is for the because they are there will not many discussions happened. And so, but I spoke of that they have agreed to that. Nobody has detected. They have taken the PRS money has been paid. That has been, it has come on record in the labor court's order also, as well as the commissioner's order. I mean, and that amount is that from that. So not receiving PRS is not there. It is not there yet at all. No way to the case. Now, as far as sir, as far as my understanding, the PRS scheme is very clear about what are the facilities they will get when they take a PRS, what they will get and what they will not get. So ex gratia payment, their 15 days salary, all these things have been mentioned in the PR, and that has been discussed with them, right? Employees union has given a notice to the all the employees that from this date to this date, PRS money will be paid, so we be there in the office, and accordingly, the payment.
So, since a voluntary retirement cannot be said to be retrenchment.
Correct.
It cannot be said to be retrenchment.
Correct.
Then, till the date they are getting, till the date they are accepted to be voluntarily retired, they will have to be given their wages.
Look, I got your, great, but also thinking that they have been told about this. It's not that look, they were not aware of their, it's not that they were not aware of the money is going to be erased. And while taking the PRS, they haven't raised any question. The application that we have filed into the labor code, no mention of anything about retrenchment, nothing about this. Now, Lordship is aware that like the under C2, only adjudicated amount will be paid. Not anything else. The Supreme Court also says that in many cases the dispute has to be adjudicated. Now we have raised a dispute saying that 14 cannot.
From when it should be paid.
Yes, 14 cannot be a benchmark. 14 the basic of benchmark, nothing is there. And closer they haven't telling closer 31,307 they haven't telling. Now only thing is not whether in 33C whether that can be adjudicated or not. And Supreme Court has many times it has said that it cannot be adjudicated. And another thing that DRS notice, DRS suspect was brought to the notice of the, we have filed an evidence, we have filed an appeals, we have given the details that we have paid this much that, and nothing has been discussed. Also the single income order, nothing has been discussed. Only thing is that the commissioner has given this before he paid this. So whether that can be done, that adjudication should have been there before, because.
No, but you see, now again sending it back, everything. Now that would again, time would be wasted, lot of it. So now the thing is that what is the, when was the money paid to them?
Yes, money paid to them, Lordship will finally see that evidence that we have filed, Lordship, that is there in the great fiction itself. Lordship, that is the next to Lordship pays petition.
Yes,
What has been paid, Lordship, that is the subparagraph 4. Lordship. 3-4. The unpaid salary, leave encashment, BRS benefit, gratuity for period from November 96 to so was paid as per the guidelines of so notification dated so. Calculation was made on the basis of on the basic DA allowed from time to time, and calculation of household allowances and medical allowances were not taken into consideration as per clause B of the same notification. BRS doesn't allow this. Prior to disbursement, a meeting was held on 2/12/2008 between management and the union. Thereafter, a notice was issued on 16/12/2008 by the then managing director informing all the employees about the payment to be made. Employees received the payment on batches starting from 21/22/2008, which is signing receipt from undertaking exhibit. So all these things they are before the labor code. In spite of this, in spite of this, these things were not taken into account. And Lordship, evidence filed by them before the labor code, that is also there, it is not part of the record, Lordship. That also specifically states that they have in fact taken adjournment for receiving the money from the department. And after that receiving the money, they have again reopened.
now this section 33
C, Lordship, C2
was filed when?
was filed on. Was filed on 3/3/2008. 3/3/2008. After this Lordship, all this BRS thing has been implemented. After this Lordship, the BRS money has been paid. Some money has been received by them without any objection. They have sought adjournment for the labor court. taking time to receive the money, all these things are account paper. Now, how this lordship is.
No, but you see, the 33 C2 was filed on 3rd March 2008. Your meeting was held on 2/12/2008.
There are several meetings happened, lordship. There, one meeting happened earlier also. There are subsequently many meetings happened because we had to pay them. And lordship, kindly see the DRS scheme. DRS plotted a payment.
Now, what is their prayer now?
No, lordship, my prayer is that lordship, I mean, we have already paid whatever is due in 2007. And after 2007, after we paid, already we have paid in the amount. And on what basis did 2014 date? What is the simplicity about this payment? Why 2014? It could have been 2015, 2016. It could have
Where is the comment, where is the improvement order?
Here or other lots of, and the page 1 month. But these issues were not discussed at all. Page 114 of the lots of he has stated that he has received the commissioner report on 4/2015, and he has passed this order on
9/3.
9th. Now, I just figure out that operating. He hasn't discussed anything on the only on the commissioner report he has allowed. That commissioner has specifically stated that the date, as the date is concerned, that is still open. That has to be adjudicated. He has himself stated. I have gone through the report of the commissioner. Yes, the commissioner has shown in his report total payable amount to the employees rupees 64 crores 76 lakh 38,000 so and so. Amount already paid is rupees 31 crores 59 lakhs 54 715. This includes all their amount about receivable, including here. And the balance amount we paid to the employee is rupees 33 crores 16 lakhs 83 84 and submitted his report in detail covering up 31/12/2014 as per the order of this court also. So the learned representative for union. No, lordship, there was no discussion on this because this issue was kept open by the commissioner. Very specifically, he has stated that as far as the date is concerned, he is not saying.
Where is the commissioner's report?
Commissioner's report also which starts from page 63. It's still also first is also that order of appointment of the. Then he gives also the introduction and the background of the case. The proceeding and works undertaken by the commission has taken our statement, their statement on this thing. And page 66 also he has given the details that what are the things we have considered. Page 66 from the bottom part. Division of scale has been also given. That unit was closed in 1996. But they have been given the division of payment also. That was put taken. The 50% DLS allowance. Revision of medical allowance was also given. Number of office members declared the allowance also. Then let's see if we come to norms and page 70 norms used in preparing the report. And he has given detailed statements, statement number 1, statement 2, statement 2, statement 3. Now he comes to us with a summary. That is the operative. Right. It's a long. I have just pointed out the relative. Serial number 6 and serial number 8. These two issues are kept. And these two issues are the most vital issue of the
Now 6 and 8, what?
8, the bottom part of the bottom, like how about the management at objective? Page 72. The learned court may decide that out of that people.
Okay, so this portion has not been decided.
Yeah, yeah, but it has not been decided, without deciding that half of a date can be just because he also government is taking. Somebody who has been worked from 2007, they will take money for other factor. It's not the government policy. No.
Yes, Mr. The,
And Lordship, I have some case law. Right.
let him, this page 72. This page 72 bottom. It says that the learned court may decide the cutoff date to be for. Where is the description?
Okay, after, I have to read out the here. That was the good thing. No, what happened in this case?
Oh, no, you see, page here. Up page 72. At the bottom it says. The calculations now to have been made up to 2007 and not to 2013 since the new version. Okay, now then,
No, calculation.
whether this,
Page
whether-
75 onwards. Page
Ah.
75 onwards.
yes. Calculation been made by him,
Here,
made by the commissioner.
from 1996 onwards.
Up till,
Up till the date. Up till,
then if it has made it, then it is,
everything has been done. And not only that, the party concerned had put their signature also. Question is very much simple, but what your lordship proposal is very much, I think it is very much beautiful. What you wanted to say, what my mind, because we have to close this case. Like, when the ultimate payment, last payment was till that date, is they are entitled to have all due. If we go through that angle, I think the problem is. We may consider it as a voluntary retirement, maybe money, color of the money will be safe. We may consider it as a retention compensation, whatever may be is done. If the final payment, when the final payment was made, till that day, we are entitled to have our all dues.
no, you see, you will have to calculate. The VRS was given with effect from which date?
Yes,
Once,
on what date?
From the closer date. No,
how do we know that?
no, that's there in when the payment.
No, on what date it was paid?
No. Suppose like this, supposing. VRS, say it came into effect say in 2020, supposing. I give the payment to you, say today. But payment is calculated from say 2020 or 2021. Could be, we do not know. So the VRS has been paid with effect from which date? That is the date. So 1 month prior, so the period prior to that will be wages. And from the date when the VRS takes effect, will be the VRS. You understand? You understand? Like supposing you have taken now supposing I give you VRS. If I say I give you VRS from August, from July, then I'll give you money from say, I count the money from first July. But supposing I say, I'm depositing the money now, but calculating the VRS to take effect from 2021, January, then the money for January 2021 should be there. So here also, the VRS has been given by calculating the amount from which date?
The amount from lots of 1996 till 30.
No, how can it be? How can it be?
Yes,
How-
because it was closed, because.
It was closed only in 2007.
Correct. It was
Then-
like, no, we have PRS of people who scheme as being state unpaid salary. from the
One thing,
What's
to
it
be,
called?
all right,
Unpaid salary
very clear.
From a particular date. So they have an application of things that I haven't been paid from. So from that period, the PRS calculation. That people, there is an unpaid salary of the date. So from 1994, it was closed. And there is no 1996, they have a new date.
How can it be? Because the earlier award is there also.
Yes, no, that's what I'm saying, okay? So award also says, I'll come to the award, or significantly come to the first award.
Because technically that is very.
Yala. Oh, not yet.
Kindly come to page 20.
Yes.
So 20
The award.
is the award person.
Like,
It was
it's
passed
a-
on 2007. Now two issues have been referred to, A and B. A is noting whether the management of some sponsor is stopping the payment. Payment of
Yes.
salary, payment of wages, salary, health benefit, and other issues. That is not included. And second is also important, if not, what relief of compensation employees are. These are two issues. Now, let's see, in this case, there are, case 21 only. There are three. There are three.
Yes.
The last line it says, see, at last production activities for factory were taken to grinding hall.
Correct. But then you come to page 27.
But 27 says,
Last three paragraph.
yes, sir. This being the situation, I'm constrained to hold that stoppage of payment, wages, salaries, retail benefits, and other dues were not listed.
Correct. Now come to the next.
And being so, I am of the view that employees who are still in service are entitled to the benefit as provided by subsection 6 of section 25(4) of the Industrial Dispute Act. So it will be so, so now at this point of time, because they were,
So this award has been passed in 27 March 2007.
correct, at
So as of till that date,
they were working.
they are working and they are supposed to be given
Right.
service.
Correct.
So the question of 1996 does not come into
And
it.
from the period of 1990.
Yes, so that wages from 96
That
to
is
2007 it have to be paid.
Correct. That we do not dispute that, that we have paid it.
Oh.
Now, only thing is that now, that notification is found for the closure. The closure has been notified later on, but 31/3/7, it was given. They have not challenged this.
Ah.
So the closure has to be taken on 31/3/2007. And we are agreeable to pay to the VRS. That like we will pay whatever the amount you give your wages for 96 and closure, right? Till 2007 we paid. And they have paid it, and they have readily accepted the BRS, because BRS gives you more. Ex gratia de BRS gives. In addition to the salary, wages, outspend, allowance, whatever, those, and all, they will get the ex gratia amount also. They have got it. And that amount was calculated at 31.
Okay, so now this is for payment only up till the date of the order, 27/3/2007. And closure has been made by, closure has been made when?
Closure has been made from 31.
Where?
That,
Cabinet decision only. Cabinet decision is
then
21.
later on the notification was given, also by here.
Where is that?
That
8/10/2007.
8/10/2007, giving a retrospective effect from 31/2007. And that was undisputed by.
31/3.
Now, on the basis of this,
So till 31/3/2007 wages have been paid.
all the amount of paid, that is what was earlier time was asked me to find an appeal bill. We have inquired to the department, and that has been paid. So now only thing is that like the remaining part of 2007, 2014, whether that can be corrected. Yeah, our humble submission here also, that aspect hasn't been adjudicated, and that how come that has come when the this closure happened in 2007, and that was not being challenged, and there was no statement in their the application of 33C2 also that like we are not telling, we are not taking, we are not abide by this, but they have really taken the VRS without any objection. They all have taken VRS without any objection, and now they are saying that no, we need to pay more. Now, what is the second about this thing? And this issue was opened by the commissioner himself, but Labour Court did not have to open this. And without acting, how can we can give it back to this order? Lordship, this is my humble submission. Lordship, at 33 C2 Lordship, I have complaints, but there has been very specifically separated executing. So only pre-adjudicated issue can be completed.
And pre-adjudicated issue is only with respect till March 2007.
Seven, because there was no challenge. So other issues, Lordship, it cannot be decided on the. But the based on the case.
So the only way out, one way out, is we send it back. And let them decide afresh on this, whether it should be from a period subsequent to
Correct, Lordship, that,
March 2007.
that issue should have been decided by, they have decided. That's the issue, if that issue could have been decided by the investor report, but investor pipeline, cannot claim because at that time, the closure was not done. But later on, it has come, so it should have been done to the investor report for adjudication. Without adjudication, that Labour Court doesn't have to be.
Yes, Mr.
Right.
It's finished, it's finished.
No.
Case
what-
was not seen, I'll
No,
play.
no, you play the case now.
The case was, I'll give,
Yeah. Let the method be much today. I think it can be.
I think we'll send it back.
It's up to your lordship.
No, I'm just thinking.
Now, let us have some cooler thinking. Because a large number of workers, more than 75 workers expired.
all that have been.
Very pathetic situation, about 300 workers.
How many judgments?
Five. I will not read it all. It's in the civilian line.
So I'm,
You give me 2 or 3, the latest one.
I
I
am
don't want to
considering,
give me
I am
five. If
considering,
it's the same line, I don't want.
I am considering his submission that executing, it is a court of execution.
Correct.
It is not a court of adjudication.
Ah,
Court of adjudication is when a reference is made under section 10. Some right is declared. The award which was passed is a court of adjudication.
correct.
The impugn order which is being,
So under 33C2, that is for execution.
that is executed, not adjudicated. But the award is an adjudication.
So,
So by dint of award, you have acted some right. Whether that right, by virtue of that right, it can be executed on.
correct, so it has
And
been.
what he wanted to say, in order to execute this thing, the court has to decide some new thing, which is not funded.
Correct.
For that reason, he is confessing some judgment. I'm also agreeable with your judgment. You
Correct,
can
correct.
let him place it. No
Correct,
problem.
correct.
No,
So-
my submission, just a minute, I will not, one judgment, constitutional bench judgment is also, I will not place it down. I have given a note here. An establishment may be closed. It does not mean all the employees are retained.
You see, that, now you see, because of the definition that we have taught, there is no question of retrenchment. There's no retrenchment because because persons who avail of the voluntary retirement scheme.
No, it is his case, not my case. What he wanted to say,
No,
what he wanted to say.
anyway, I'm not going into that issue. The issue is this. The award passed on 27 March 2007.
I have 1 minute.
Yeah.
By virtue of that award, I accrue some right.
Yeah, you accrued right.
That right is not confined to the extent of 2007. It was-
No, how? That is the exact point.
Yes, that is the exact point. If we can understand this thing, everything will be solved.
Yes.
Closure was not telling.
Oh, I am not challenging the closure. When Even I cannot challenge this closure because this honorable court has specifically passed an order in this regard that 33C2 will continue, but in 33C2 you could not challenge closure. I am not challenging closure. Repeatedly I am saying. I am based on this closure. I am agreeable to closure. Now I am based on this closure. I want to have my benefit under section 25N.
I forgot to copy this one. Only thing for lots of whether at any point of time before the trial court issue was filed, whether this court before whether that issue can be. Once they have taken the VRS, it's no question of return.
VRS amount was deposited to the company and it was disbursed to adjust with the salary. Right now, my friend has to say, the amount which was deposited for VRS amount, it was adjusted with the due salary. Does it mean that I have accepted this?
I do not know. We'll have to check your account. You might have used it already.
No, he has said so. But it is a fact. What he has said is correctly said. They have deposited some VRS, they took some loan. And it was kept in their account. And it was adjusted with the due salary.
Kept in whose account? The workman's account.
Company's account.
Company's account.
And it was adjusted with the due salary.
And company has given it to the
Workman by adjusting the due salary. This case, I am also agreeing this thing. Yes, it has happened. You took loan from Asian Development Bank, you kept in your account, and you paid this amount for adjustment of your dues area. Does it mean that?
No, it was for VRS. They have agreed specifically in the VRS. It's not for the note that kind of article cannot be used. Yeah, they have agreed.
No, you see, no, the issue is this. The issue is
One document.
what?
Document.
The issue is that still you are deemed to be still in yes, you're still deemed to be a workman by the award of 2000. Correct? And that you should be paid your wages. Correct? Now,
Look, I paid my wages, still I am not retained.
correct, till you are not returned or till you are not taken the voluntary retirement scheme.
Yes, either voluntary retirement scheme or still I am not retained. Now
Was the voluntary retirement scheme taken into consideration by the commissioner?
Yes, but
for the disbursement of all dues.
It was taken.
Huh.
Now, whether the closure of the mill, that notification was taken into consideration by the labor court.
Yes.
Where?
Labor court specifically, because empty judgment I have to read, otherwise we'll be in trouble here. We have reached, just now we have read the. Now, yes, labor code has specifically dealt with that we are not in questioning the order passed under 25(4).
Please give me some more.
Anyway, this page 72 is again there. Please come to page 72, the last three lines.
No, that is page 72 is the, look, commissioner is not supposed to decide that thing.
Correct.
Commissioner is supposed to calculate
But
the amount on the basis of the order passed by the labor
correct.
under section 33C.
No, please understand.
No,
So don't tell me the law. Just tell me this thing. This page 3. Page 72 says, the learned court may decide the cutoff date to be followed. Okay. Now this is what the commissioner has said. And what is the decision of the labor court?
that is
The cutoff date, what has he said about the cutoff date?
the
Huh?
15 order is a 120.
no, 58.
Let's say earlier order.
That's the earlier order. We're talking about subsequent to that. Under, you see, when they came under 33, C2, the labor court had sent it to the commissioner. The commissioner thereafter made the calculation and then said, the cutoff, the learned court may decide the cutoff date to be followed. Now, this commissioner's report was taken to the labor court again, and at page 113. It has
113.
113. 113. It starts from 113. He has not made any discussion as to what should be the cutoff date. It just said that he submitted his report in detail, covering up to 31/12/2014. That's all. He has not decided which should be the cutoff date.
31/12/2014,
Yes,
as per the order court,
correct, correct,
dated 2030.
correct.
Court passed this order 18/7/2030. And order 18,
Correct, correct.
and
You see, what is, the court had passed the order in 18/7/2013. The commissioner made his report till 2014,
31/12/2014.
correct? And it also said in page 63 that the court will decide the cutoff date. But the court did not make the cutoff date. That is what is pending.
But you also want to say, when the commissioner has said that the court has to decide the cutoff date,
Cutoff date.
and court has not decided that date.
That's all. That is all. And since and without making any discussion on that, has simply just followed the commissioner's report.
Report of the commissioner shall be treated as a part of this order. The learned representative of the union as well as the learned council for the opposite party has already put their signature on the report of the commissioner as a token of no objection.
For the token of the office. So they have agreed.
They have agreed. That is why they have repeatedly, but even though I have filed an application for disposal of this thing. And you will also find their signature. The secretary of the government, you will find at page 110, 111, 12, their signature. Yes.
Provided that date will be calculated by the, decided by the labor.
No.
They are
Lordship,
again,
they are there in-
Vasanto Kumar Soikia, Vasanto Kumar Kolita, Union side, Concordev side, your workman side,
But what was the,
managing director,
but what was the observation of the commissioner?
managing director.
What was the observation of the commissioner at the cutoff date will be decided?
The depending.
What decided thing that has to be decided? And if we have, because we agreed to the commissioner, we have agreed that like.
Sorry, why you have agreed, then why you agreed?
No, just a minute. So this,
signature.
no, but then you see, one thing is, this signature has been made at the time the issue was before the commissioner. Correct?
Correct.
The report of the commissioner
Yes,
has been signed by both the parties.
Yes.
Correct? Mr. Dasgupta?
Yes, sir.
Now, if it has been signed by both the parties, if it was agreed by both the parties, what was the requirement of the commissioner to say that the court will decide the cutoff date?
No, then, one thing, yes. There may be a probability that court has to decide the cutoff date. And after deciding the cutoff date, court has passed an order on that, till that date, and it can be visible from this order. On this calculation, say for example,
This is only the amount that is to be paid.
okay, yes.
If they decide that
The-
it will be till,
Okay.
now you see, you have got to read page 63 as a whole. Just read page that last three lines. We did not read it properly.
page
Page 63 or where is that? Page 113, where is that from?
that,
That cutoff date.
Okay.
That cutoff date part. The commissioner's report.
Commissioner's report, also, that is, that is, 72.
not correct. Yes, page 17, last paragraph,
72.
last paragraph.
The learned court may decide the cutoff
Decide the
date.
cutoff date to be followed. As from the reading of the order of business case number,
The date of closure is not
page
specified.
13, which read as under, the date of closure is not specified. As a result, the without taking into the legality of the closure of, without taking, as a result, that without taking the legality of the closure of Assam Span Mill from the debt, so pure legality of the is not questioned. Calculation have been made up to 31st December 2014. It is up to him. 31st day. In case the employee retiring date on or before 31st December 2014, retirement benefit has been calculated. So person who died before, they will get on that date. In case the employees whose service period has not been completed by 31st December 2014, no retirement benefit or other termination benefit has been calculated. It is given the guideline. Calculation have been done on the basis of the claim made by the union and the claim which has not been made by the union has not been considered. Provident fund contribution of the employer and the employee has not been considered. So many things have not been considered. Claims of the employee do not exclude professional tax, provident fund corporation. Revision of pay rules 1998 of Assam State Form Government as accepted by the management has been adopted by me, including the various government notifications, revision of pay, and DRNS allowance and other allowances. Bonus has been computed as per the payment of bonus act. However, as demanded by the union, bonus cannot be paid. Employee drawing basic and DRNS allowance excluding minimum wage exceeding 10,000 report as the law, in my opinion, does not allow so. Leave salary allowed. Then gratuity has been provided, payment of gratuity, all these factors are given.
You please come to page 72 again. Come to page 72.
72.
72.
Yes.
Come to page 72, come to from however, the third last paragraph. However, the management has objected.
Very.
At the bottom, third last paragraph. However, the management has objected.
72, no?
Yes.
Last paragraph.
Third last.
However, the management has objected to use. This is
Yes, yes.
use of the above process of calculation as maintained and has maintained that the calculation ought to have been made up to 33,700 and not up to 33,1200. Since the mill was closed with effect from 33,000, as per the notification under the percentage, the learned court may decide the court date that we
Cut
call
off date.
cut off. So what want to say, it is not an agreement. So,
The calculation made was signed by both of them. Calculation has been signed by both of them.
so far,
But
both
the-
calculation is correct,
Calculation is correct, but the
but the
cutoff
cut off
date
date is defined.
has to be decided. That's all.
Now, cut off date has to be.
And now we have got to see that page 113, whether the cutoff date has been decided on.
Both of them. Three, one. I have gone through the report of the commissioner, that's page 114. It appears that the commissioner has shown his report. In his report, total payable amount of the in detail covering up to 31/12/2014 as per the order of as per our order of 18/7/2000, though he has not specifically stated that this must this must be the cutoff date, but he is agreed upon.
Who has agreed?
The in
But he has
detail
to-
covering up to 1,000, he has said, he has
But he has to
calculated.
give a reason, no? Why? Cannot be just like that, yes. It should be, there should be some discussion, some reasoning, some finding.
Justified.
Yes, to justify. Now this 18/7/2013, where is this order? 18/7/2013 order?
Why the commissioner was appointed?
No, where is that 18/7/2013?
That is, your lot will find at page 46. They're long order. In what manner the commissioner has to calculate, he gave a guideline. And according to each guideline, it was calculated and it was agreed upon by the party. But one thing the commissioner has said that so far the cutoff rate is concerned, is not in my jurisdiction. Probably he is correctly. He was called upon to make a calculation. He was a chartered accountant.
Now, does this 18/7/2013 say that calculation has to be made up to 31/12/14?
That was. Probably that was.
So where is, so the tribunal had to make, the labor court had to decide the cutoff. That is what the committee must say. Because now you are,
Very
like,
much correct.
Huh?
Commissioner is very much correct. So he has no jurisdiction.
so we'll send it back to the labor court, let him decide the cutoff. date. Alright,
No. Should be level.
no, this is order
Level
by the labor court.
go to the section 33C2.
No,
only
no,
the labor court is the
it
jurisdiction.
all through it has been labor court, you have not put a challenge to jurisdiction. Okay, we can-
We got those here. Like, those things, because of they have issued.
No, Mr.
They
Rao,
have four issues. No,
sorry, you see, the first order passed,
I find it, I because, whether if we have.
Yes, section 33C2 itself here, right?
Because I.
Section
go to the labor court now, we'll set aside this order of 1950 and you go back to it.
Only a cutoff date has to be.
Only that.
So for the mode of calculation is concerned,
I'm
is
not
correct.
to that merit. I'm not going into those issues. These issues, so they will take it up. Whether the commissioner's report is correct or not.
Then only give a cut off.
I am just going to say cut off it, whatever issues you have to take it up.
By deciding what to cut off the whatever issues come.
Yes, whatever is,
They decide because there's not a block money, it will say.
yes, yes.
Just a minute, let us clarify it, otherwise we'll be in trouble, not to get it. Whether the level would start it is
Place clause.
Yeah.
I'll just place it, so I'll not wait out. This, 32
Type there's a paragraph.
paragraph I have given written in the passport.
No, I have thought that. If you are lucky. Because if you are lucky, want to place this.
No, is it required?
If you place some judgment, otherwise I have to do. I
Is it
thought it
required?
was judgment. is
Forget the
in fact-
judgment.
Only 30 please keep to that.
Only that, I'll just read that.
That respect, I don't think you also plan.
No, if you want to place it, then I will have to place it.
Okay, you make it two judgments.
I
Two
think-
judgments.
Yes,
Mr. Counselor, two judgments.
because otherwise I will be in trouble. I will place one constitutional bench judgment.
Both of you are placing constitution.
All right, I will place only one judgment.
Then you place two also.
No, I will place only one judgment. Paragraph 30 and 32.
You have written down at the top.
Yes. But- Paragraph 30. Paragraph 30 and 32 is very much clear. You are lucky to have decided what your offices are, I will not stand in. Well, this section 29 was challenged. Validity of the section 29 was challenged. And upholding the section, the Supreme Court has made some observation to the effect that the closer and retrenchment are two distinct concepts. Okay, you can close down your structure. That does not mean that you have retained your. All
That means they continue.
they will continue until the date of retrenchment, until the date of retrenchment procedural safeguard, there is retrenchment compensation and lot of, they will follow.
I agree with that. Only point into the.
If your lordship,
Which has come.
I will be very much grateful to your lordship. So lordship, make some of that on the window. Otherwise, same problem may come.
With regard to what?
With regard to how the cut-off get has to be done.
That
Uh,
was-
no,
Right
why-
now,
why
your
do
lordship did not pass any judgment. Your lordship passed the judgment after vacation. Might
No, no,
apply your lordship.
I have got enough, reserve judgment to.
30, paragraph 30 and 32.
That lordship has to decide again.
Yes, I have to decide the entire thing. Basically, I'll be leaving nothing for the labor court. I'll be basically telling him, you have to decide this week.
And that's why
I cannot do that.
I have given a note of. I gave a note.
Anyway, now we don't have to go so far into the issue. My God, it's as big as the,
No, I only quoted the section. Nothing else. My submission is in only one paragraph.
okay.
I will just quoted the section.
Okay.
The paragraph.
Right, heard Mr. A. Kalita, counsel for the petitioner. Petitioners, petitioner. And Mr. A. Das Gupta, senior counsel for the point number 2. Assisted by Miss
Either.
Pidas. The petitioner has paid for setting aside the judgment and order dated 18/7/2013, passed by the respondent number 1 in this case number 3 of 2018.
That will be
18/7/2013.
lordship, that will be 90. 90.
18/7 is the original, that is cannot challenge.
I mean, I'm telling this.
They set aside the order dated 9/3/2015, passed by the learned, not passed by the labor court body, in this case number 3 of 2000.
90.
Yeah, I've seen.
9/3/2015. Not that, the first one is not under challenge, yeah. First one.
Your lordship, I also indicate the order dated 18th because of allowance. So 2015 order is consequential order of 18/7/2000.
let me start the order, that I'm just indicating what is under challenge, that's all. So that straight away we know what is the issue. Right, the petitioner's case is that the Assam Spun Silk Mill was closed by the management in the year 1990. As no wages were being paid after closure of the mill. The point number 2. So I submit the complaint. The point number 2 with regard to wages.
They have they picked up for wages from November 1990.
So they filed an application under section 33.
No, 33 seats later. Earlier.
That's one number 2 and 3.
There is point number 2 and 3 submitted, what?
Labor and Employment Department has been referred the matter to the government.
I know, but prior to that,
Prior to that, phase 22 also the fine. Yes, there are phase 22.
that's it.
It is the award. Eight 46 by given
243.
843. What is our given?
Submitted an industrial dispute,
Yes, no.
to the
The labor,
to the labor department.
labor and employment department.
The labor and employment department regarding non-payment of wages since 1990. The conciliation proceeding between the parties having ended in failure. The government of Assam, Labor and Employment Department, thereafter referred the matter to the labor court, to the industrial tribunal, industrial tribunal from Guwahati. By
Notification dated 28/10/2014.
Right notification dated
28/10/2004.
28/10/2004.
Well, to come to page number.
Wherein, no, wherein the following issues were raised.
Yeah.
That is page 20. Next paragraph. The learned tribunal thereafter passed the award dated 27/3/2007 by holding that the stoppage of payment of wages, salaries, retirement benefits, and other dues was not justified. And as such, the employees / workmen were entitled to service benefits
Subsection 6 of
as provided in subsection 6
section 25.
of section 20.
Correct.
It is 26. Oh,
No, you're not to, it is a wrongly that.
Correct. Subsection 6 of 25.
this as provided in the Industrial Dispute Act 1947. Don't say the thing. No, don't say it. First up. The management / writ petitioners were directed to pay all the benefits to the retired employees who had retired or died after 1st November 1990. Next paragraph. As the,
Retired employees and the other existing employees.
it's only with respect to the. Next paragraph.
Last paragraph.
Huh? That's all.
The management organizations are directed to comply with the direction given above and to pay all the benefits.
To who have retired or died, that's all. It's not spoken of the ones who are working. That is prior to that. Right. As the, next paragraph, as the award dated 27/3/2007 was not being complied. Okay. In reference case number 16 of 2004. Reference case number. As the award dated 27/3/2007. Passed in reference case number 16 of 2004 was not being complied with. There is point number 2. Submitted an application under section 33G bracket 2 of the Industrial Dispute Act 1947. Wherein after referred to as system. The labor court, before that, in the labor court, what? The labor court thereafter passed its judgment and order dated 18/7/2030 in this case number 3 of 2008, right? Registered as this case number 3 of 2008. In this case number 3 of 2008. By holding the writ petitioners were to pay the dues of the workman immediately, including the amount already assessed and to be assessed in terms of the award passed in reference case number 16 of 2004. Consequently, Commissioner is under what provision?
Commissioner can be appointed under section 33C2.
Accordingly, the commissioner to be appointed under section 33C2
Let me get,
of the act.
let me get it confirmed. Yeah, you have to continue. I will confirm.
Ah. That is P, C, actually. That is C.
That is C3.
Was to, was
Appoint a
to,
commissioner.
was to submit a report to the labor court. And thereafter, the labor court was to determine the amount payable after considering the report of commission. So, next one. Pursuant to the judgment and order dated 18/7/2013, passed it. It is not judgment, it should be order. Right?
Order.
Yes,
Just the judgment, not the order.
Because
Passed
the
in
court
which
of
case
appeal-
number 3/2018. The commissioner appointed under section 33C submitted its report dated 29/1/2015. Along with the wages payable to the workman up to 31/12/2014. The commissioner in para 8 of his report dated 29/1/2015 held that the labor court was to decide the cutoff date to be followed with regard to the wages payable to the workman. Next one. The learned labor court thereafter passed the impugned order dated 9/3/2015 in this case number 3/2003 by stating that the commissioner's report was accepted and that the writ petitioner were to make payment as per the commissioner's report. Next slide. The petitioner counsel that a reading of section 33C2 of the Act shows that the commissioner could 33C2 and 3 that the commissioner could only execute.
the labor,
Huh?
labor code cannot.
No, the commissioner could only what did you say? What was the submission?
Well, see that calculation which is made, says made by the commissioner, he has kept what which of it, or the.
That you have already said.
That hasn't been decided.
That you have already said.
So that another thing that the DRSP, that DRSP is the second, also will not.
Then Indian metal.
That entire matter. No.
Then he worked in that was.
What your lordship says, let it be done. It is better. It's not debate, yes.
Huh? So that submits that.
There was no education as far as the cutoff.
As the commissioner who had been appointed by the labor court, had reported the submission of the management that the calculation with regard to the salary payable to the petitioner, payable to the workman, ought to have been up to 31/3/2007 and not up 31/3/2030. Since the mill had been closed with effect from 31/3/2007. As per notification dated 8/10/2007 of the labor court ought to have taken a decision as to the period for which the wages was to be paid to the workmen. That is point number.
Then my submission may continue.
First of, however, the learned labor court did not take a decision with regard to the cutoff date to be applied, as had been reflected in the commissioner's report. And as such, the impugned order dated 1 month.
Nineteen fifteen.
1950. Past case, this case number 3 of 2018 to be fixed.
Well, my submission may continue.
Mr. A. Das Gupta, learned senior counsel for the point number 2 and 3. Submits that
That the cutoff date to be the date of the date of retention.
the cutoff date to be of the workman should be the date of retrenchment.
And the retrenchment and the.
And
there are
as-
two different concepts.
And that retrenchment and
And.
closure of the mill are two different concepts.
Concept. Retrenchment is considered under section 25N and closure is section 25.
So the people means that,
My legal position also at least clear as.
okay,
Otherwise, I agreed. I don't know why my learned.
Yeah, again,
Uh,
hesitated there also.
we close this, we won't say this.
You
We'll say that.
need to say all the.
Then you can't be saying that. Yes, Mr. Das Gupta, learned senior counsel for the, Mr. Das Gupta, learned senior counsel for the point number 2 and 3 submit. That as the commissioner's report had required the labor court to make the cutoff date, to determine the cutoff date, the labor court may be given the opportunity, may be given the opportunity to make the cutoff. Correct? Make the cutoff date.
Then go to your lordship.
Huh?
Not
Okay.
to-
Okay, not through you.
not
Okay,
to
this
your-
is Mr. Das Gupta, learned senior counsel for the respondent number 2 and 3 submit. That there is no infirmity with the decision of the labor court, as the same as apparently been made on the basis of the report made by the commissioner, which he was competent to do. Next, I have further learned out from the report of the commissioner dated
29/1/2015.
29/1/2015,
Please,
page 72.
Page 72.
Not when I have to take it from. We take it from here. Page 72. Inverted comma, the learned court may decide the cutoff date
Yeah.
to be followed, comma,
That will be better.
as from the reading of the order, this case 03/2008, page 13, which reads as under, comma, the date of closure is not specified. So, next one. The impugned order dated
90,
1/1/3,
90.
9/3/2015. States as follows. Taken at page 114, from I have gone through to to the end, okay? A perusal of the impugned order dated 9/3/2015 passed by the Senate Labour Court, Guwahati, in this case number 3 of 2008, 3 of 08, clearly shows that the Labour Court, Learned Labour Court, has not determined the cutoff date to be followed. And it has blindly stated that, and it has mechanically stated that the report of the commission is accepted. No discussion has been made by the Learned Labour Court as to why the report of the commissioner is to be accepted.
Then they cut off the argument was 140.
Well, the reading of the content of the commissioner's report, coupled with the stand taken by the party and the fact that the stand taken by the parties that no, and the contrasting stand taken by the council for the parties that PRS has been accepted by all. No, as to, no, as to whether PRS has been accepted or not by the work, by all the workmen. This court is of the view that if you ordered it itself is not sustainable.
Whether they have the restraint for.
I'm not saying, I'm not saying.
PRS is considered. Yes, farm worker has a perfect PRS and farm worker. has
That's why I said whether, I've not said, I've not taken, I've not made any decision. I've just said whether all have taken VRS or not.
The problem is that when High Court passes an order, the labor court is very much influenced by that order. They will pass this order in terms of that.
No, I
So
said whether.
it does not indicate anything. So
Okay.
that the labor could get influenced. That is my
Okay, okay, I will cut that part, of whether,
Well,
from whether you
But
can.
it's my.
And keeping in view the contrasting, stance taken by the party, the council for the party. That's all. This court is of the view that, the Learned Labour Court should have taken a decision,
What is it?
or I should have taken a decision with regard to whether a cutoff date,
What could be the cutoff?
as to what would be the cutoff date. Cutoff date.
You are considering all this.
So, no. No, I will indicate that, that you, that I will indicate. No, no, just a minute. I will indicate that you can make submissions.
Yes.
Accordingly. The, impugned order dated February passed in which you have hereby satisfied. The case is remanded back to the Learned Labour Court, Guwahati, for taking a decision on the, on the cutoff date to be fixed by posta. The parties are also given the liberty to, raise, yes, any other issue which has not been reflected in this order. And which has been, as per law, as per.
Any point they can take. If lordship makes an observation, they will be getting.
Okay, maybe.
Is my opinion.
So should I make a decision? Do you want me to write the judgment?
I don't think when you, because my judgment, here, so for the constitutional judgment, it is concerned with the date of extension. Has to be defined.
I need to review the order first. Yeah.
Public.
I have been interested in morning after.
Yes, we said 2 o'clock.
Yes, at 2 o'clock, but then I only, since I did not find it here,
So he has informed me that he has undergone prostate operation.
Prostrate. But then there in the morning, he should have told you that.
So no, he was not there. He entrusted his junior.
To,
Unfortunately, he is not there.
oh,
Therefore, since melodic bass is sometimes proceed below.
I hope Melody Lordship fix it after vacation. Preferably in the first week of August. So we can take contact for delivery.
okay, yeah. If the, as that time, and CJ counsel appears for the petition, no one appears for the respondent. It is, term appears for the respondent. Yeah, so submit says that are submit that it appears that the respondent's counsel has undergone a prostate operation. Accordingly, this matter in the first instance. Matter. What is this matter?
Award.
So we again. It says that Gupta appears for the petitioner, no one appears for the respondent. Accordingly, that interest of justice is the matter after the petition. Huh?
Art conflict later.
Contact matter,
To terminate matter.
termination.
Yes. The consumer state might have been both.
I don't know, this petitioner has been, adjourning the matter time and again. We listed after the vacation. No one appears for,
The thing, yeah, madam, if, thing,
oh, stays there. Oh, yeah, yes.
and I'm waiting for the. But the buses have been, but the big pump, the car, is out. It is right. So, that is why that is like. Because the.
There is a stay order in your favor.
Lordship makes fixed any then.
Well, what interim order is there?
We finally get the contract. For instance, that is finally was not. Supposed to be.
Show cause notice was issued for termination.
Yes,
And that has been stayed.
no, conventional step. So, if, 7 days, 48 years, everything was down, I could say they're not.
Okay, right. Huh? I know, I understand. Yeah. Okay, right. Adjournment prayer has been made on behalf of the petitioner's counsel. There is a stay order against the termination of the petitioner's contract. This is the matter, give a date.
17 of July.
This is the matter on 17th. No further adjournment will be given on the fifth. Huh?
I never read.
Mr. S.K. Medi appears for the. So for,
My lord, the interim is extended.
interim, huh?
Interim was not. Okay.
Let me see, interim extended or not, last after this.
You said it was interim order. You have to not.
Then you said that interim, not this thing. No, not extended. Not extended since 22, 23.
Yes. They have subsequently, but they are active. You have to make it.
Huh?
You have to make it.
Okay, don't say that. So if there is no stay order, then what is the hurry?
Stay order, when the problem also is stay order is not, people, stay order is there, but we have to this file for taking that order. If railway is,
What?
railway is there.
That stay order. You see, what is the difference between stay order and interim order?
Yes, I understand.
What do you mean you understand?
Let's be clear, clarify that. Yeah.
There is no stay order. And initially there was.
Yeah. Let's be clarify that.
Give me the main case.
Four eight double one nine.
If you notice,
Demand notice was there.
Four eight double one.
subsequent to 29/7/22, there is no continuation.
Yes.
Right.
Your lordship, they have filed this IA. This IA is for vacating the stay interim order.
Yeah.
They have filed this.
They have filed it, but then there is no continuation of the stay. And as per the full bench decision of this court, this goes.
This entire thing could be allowed. MPR method would be hard. So the entire matter is there.
I will not say anything, leave the matter of you decide on. Not taking it.
Apply.
Petitioners L2,
But what tell us to help
L3. Then. So what is wrong?
others, NIT is a 12 method. As per the NIT method, the rate should be quoted as per schedule or schedule of rate below maximum 5% rate. Quoted more than 5% below will not be accepted. And accordingly, L1 Peter Midul Hazarika, who bided 10.14% rate is rejected, and but L2 bidder is not allowed the work, and L3 bidder has taken.
What is the difference between L2 and L3? Page 13.
Page, uh,
Page 14.
Page 13 is the comparison minus, wherein L1, L2 bidder fulfill all the conditions, but
Just a minute. Ananta Borgohain is petitioner.
Ananta Bhargava is the
And then number one is
number L1 bidder.
L1. L1 is not required. You want, where is L3?
L3 is at serial number 3 number.
What is the difference in the money?
Pilot, we have not submitted income tax return last 5 years. Pilot. Then is the financial turnover is not also not submitted. Pilot.
Is there a stay?
Pilot, initially there is a stay as per order 412. Pilot.
No. How do I, let us see how much is the amount. Okay. And page 14.
Page 14.
Page 14. L3 abidit. L2. What is the difference? Okay. L3 has been given. Now, what is the stand of the respondent?
Respondent. As per respondent Pilot, due to this poor performance showing during execution of previous work under this division, you has not given the work matter. But
To you.
But my lord, earlier only one more work is executed by the my lord, and in that work, my lord, because COVID situation, some delay in that, but we have completed the work, my lord.
You see, they have said that you might have completed, but due to poor performance. They have said that you've got poor performance during execution of the previous one.
My lord, they have keep a complete certificate of
So,
that work.
supposing you're supposed to complete a work within 1 year, you complete it after 3 years, that is poor performance. You might have completed.
That is only the COVID.
I don't know. You have not, now that is that you have maybe COVID, I think you stated it, that it is due to COVID. Yes, what is, Mr. Brian, what is the, poor performance? What is wrong? Look, it's like this. Supposing, say, even in say interview, say you are going to take a junior. You have got one junior who is smart, speaks well, and does work as you want. The other one, you give him work, he will answer you after 3 days or 4 days. Doesn't dress properly enough. Now, who will you choose to be your number one junior? The bad one or the good one? And both have passed LLB, by the way. It doesn't mean that just because both have passed LLB, they are both equal. No. Similarly, you are a contractor, L3 is a contractor, but your job is slightly worse. Your past experience is not very good. But performance is not good.
But
It does
not
with
the
the,
criteria in the NIP.
huh? No, that is a legitimate reason. That is a legitimate reason. Let us see the NIT. Let us see the NIT.
NIP is the state 12 months.
Let us. So there is no conditions of the no tender conditions. Huh? Is there any more documents? There is HE category. It is depicted the second category, the first side, just the right to accept or without writing. I think it is. Undersigned or accepting authority is not bound to accept the lowest rate. And he has given the reason for it.
Final then of the final idea. L3 bidder, but he did not have the word good kind also.
But where does it say? How do we know that?
Pilot, case number 13, Pilot.
Yes.
Full pen needed and machinery. Not as per tender required.
Is there a stay out here?
Order is 412.
Yes, how are you giving? You think it's page 30. This not submitted, that not submitted. And another thing, Mr. Council, you see, they have said that you have poor performance. You have not denied this. You have got to deny it.
That is the only thing, the COVID situation,
You please deny it. If you don't deny,
the completion certificate also. After check.
you're still not understanding me. You have to spoon feed you. You have to spoon feed you. See, what I'm trying to say, is, if they say something in a counter affidavit, which according to you is not true, or there is some reason that can be given for that poor performance, you can explain it by way of a rejoinder affidavit or affidavit in reply. Otherwise, what happens, as per law, an uncontroverted averment is deemed to be valid unless you controvert it. So what to do? I decide the matter or what?
Then after that,
Who's for the other side? For the private? You're for the L3. But you have not submitted all those documents. I think the records are necessary. Okay. Right, for the parties are present. Mr. M. Buyan shall produce the record on the next day. The petition is also given liberty to file affidavit in the file. It's